వేస్తాం తర్వాత
Oh, no mention. Good. Yes, start, madam.
I beg to appear.
Yes. So we'll issue notice. Yes, you accept.
Let accept notice for the respondent petitioner.
All.
Millard,
How much is the delay? It's not
11
working.
days.
I have not been served
11
with a
days.
copy of the IA, Millard.
Not working. Which IA condonation?
I have not received papers, Millard.
All you are appearing for all respondents?
No, only for one first respondent.
Not working, madam. First respondent. Let a copy of IA 2 of 23 as well as 3 of 23 be supplied to learned counsel for respondent number 1 during the course of the day.
Yes.
Issue notice to remaining respondents list for analogous hearing along with WA number 929/2023.
Where the
entertained a similar
Yes,
appeal and granted an interim order. That's why we have said that it should come up along with
I'll
WA.
only clarify, Millard, since your lordship said, Millard, a writ petition similar is writ appeal is admitted. In fact, Millard, it's not similar. Learned judge disposed of 3 writ petitions by an independent order in each defect.
We have not passed any order today. You filed objection.
he has initiated the contempt proceeding. That is only the trouble.
So let him, what to do? There is a condonation of delay. We have to condone the delay.
Monday it may take.
So you have to take out
I'll take
remaining respondents who are there.
I'll take it note.
Yeah, see respondents remaining.
Respondent number 2 is already a.
It's not what is this question? Huh? There are 2 respondents. He is accepting on behalf of one. Other one we will issue notice to respond number 2, personal notice, whatever proof of service list.
No.
What is this, sir? Huh? Yes.
My lord, this is the writ appeal with an inordinate delay, my lord. The delay is around 2,000 days, my lord. 2,950 days, my lord. About 10 years ago, my lord, this appeal, the writ petition was dismissed, my lord. The client says, my lord, that a senior counsel was appearing, but his clerks and instrumentalities, my lord, always kept representing to him that the writ petition was pending. And as he was in uninterrupted possession and enjoyment of his lands, my lord, he never thought anything about it. Suddenly, in the month of June this year, my lord, they started interfering with it, saying that you lost the case long ago. It is at that time he went back to these people, my lord, and still he was told that it is pending, my lord. Then he approached our office, my lord. We found out that this appeal was already, this writ petition was already dismissed 10 years ago. So we have filed a writ appeal against that, my lord. There is a delay of 2,950 days, my lord, which is inordinate, my lord. But there is a direct judgment of the Supreme Court on this point, my lord. If my lord would like to pursue it, may I be allowed to pass it on, my lord?
What judgment?
My lord?
What judgment?
This is Radha Krishna Rai versus Allahabad Bank, my lord.
On what point?
At this point, my lord, let me read paragraph 5 of this judgment, my lord.
So what is it about condonation of delay? So it's a fit case where you should file a complaint against your counsel to the against your to the, in the bar counsel.
Very senior counsel, my lord.
So so the court should take upon the responsibility because he is a senior counsel, right? What is the suggestion? Is it not a case of professional misconduct? Is it, you tell us, is it not a case of a professional misconduct, misleading the client that a case is disposed of?
It is, my lord.
Would you ever do it?
It is, my lord.
Would you ever do it?
No, my lord.
Then what can be done?
My lord may peruse this.
Have you implead him? We will take this thing out. Implead him as a respondent.
I will implead him and his instrumentality.
What about merits?
My merits of the case, my lord, it is the matter in which an Inam land was sold to somebody, my lord. And Inamdar sold the land to somebody, my lord. The full bench of our High Court, my lord, has held that Inam lands cannot be sold, my lord. And as this man is the protected tenant of that land, my lord, his succession having been approved by the government, by the revenue authorities about 30 years ago, my lord.
You are claiming occupancy rights, right?
I am claiming occupancy rights.
So,
which I have been in occupation since the independence.
So where are the documents to show your position? The learned single judge has recorded a finding that there is no material on record to show that you were ever in possession.
My lord, there is a Panchnama, there is an order of the lower court. There is a Panchnama, there is an order of the lower court that I am in possession, my lord. The Panchnama is part of the file, my lord.
Where is that?
1982, my lord, page 26. 26, my lord, page
26.
It is the succession, my lord.
This is not succession, but it's a restoration of possession. That is restoration of possession. The order is for restoring the possession. He admits that he is not in possession.
No, so which order is in his favor?
No, my lord. To restore the possession.
In his favor.
To restore.
When was this order passed?
83.
82, my lord.
So thereafter, when were you this thing placed? In this order is passed by whom?
Tahsildar.
The order under appeal was passed in 204, my lord. 2004. Page 24, my lord.
The section 32, whether it is implemented or appealed.
No. Thereafter, this order was passed in 82.
Yes.
When he was placed in possession.
Not that. Whether the appeal has been filed, it's not.
My lord, we are still in possession.
No. As he has told us, 25/4/1982 is an order directing possession.
Yes, my lord.
To be handed over to you.
It has been handed over, my lord. There is a
that is what I mean. That's what you are required to tell us.
One moment, my lord. If there was a Panchnama also in the file. I will find the Panchnama, my lord. I'm having the Panchnama. I will find the Panchnama.
Will file means this is not an original.
It is there. 68.
This is not an original procedure.
68, my lord. It is in Telugu, my lord. 70 is the English part, my lord. 70, 71, my lord.
Order as the suggestion, what are occupancy certificate No, that's correct. Then he has been. Which page, Mister?
My lord.
Which page is the Panchanama?
70. 70 is the English version, my lord. 68 is the Telugu version.
70. Huh? 70. Now, what does it read? How does it read?
May I read it, my lord? We three members were observed as punches at there who are the occupiers, so and so, so and so, so and so, are doing self-occupation at 482, and as per Revenue Act, in compliance with the order of the revenue land, and the occupiers are removed, and that land is given to Abdul Ghaffar, son of Abdul Nabi. Abdul Ghaffar is the petitioner, my lord.
Giving an impression as if it's okay. Yes.
Abdul Ghaffar is the petitioner, my lord. He is now about 75, 80 years old.
Huh? 80 age means no what? Please read it again.
We three members were observed as punches at there who are the occupiers, so and so, so and so, so and so, are doing self-cultivation on survey number so and so, and per Revenue Act, in compliance with the orders of the Revenue Inspector of so and so Mandal, number so and so, land possessors of the above land, occupiers were removed,
70.
and the land was given to Abdul Ghaffar, son of Abdul Nabi. From then,
Who are these people?
the date of this document would be, my lord, sometime in 93. 10/6/93, my lord. The fourth line in the Telugu document.
So tell us something about condonation. When the limitation expired, when the appeal was dismissed.
My lord,
Petition was
the
dismissed.
original order of the court, which is under appeal, my lord,
Ah,
is dated 20th August 2015.
all right. So
And,
when did you come to know about? When did you come to know about the order of dismissal?
June this year, my lord. June, July this year.
Who told you?
When the other side started interfering in my possession,
When?
I came back.
June or July or date? There has to be something like it. Can't be as vague as.
We have filed a petition for a certified copy of the order, my lord. That order date may be taken 14th/8, my lord. 27/7 is the date of the application, my lord.
So when did you must have said in your application for condonation of
Yes,
relief.
my lord.
What have you said? Please read.
Late in June 2023, I have said, my lord, in the 5th paragraph. Late in June 2023.
Who told you that it is decided?
Those people kept
Counsel.
on saying today also that it is still pending, my lord.
No,
We
no,
from
who
the
told,
computers.
who told you then it is decided?
When they started interfering in our possession, my lord.
They means respondents,
Yes, ma'am.
private respondents, or everybody including Tehsildar, etc., everyone.
I would really not know. He was told that there was interference in his possession.
What are your averments? Please read.
However, some persons claiming under respondents 3 to 5 started interfering with my use and possession of the lands in June 2023, and my against contacted the instrumentalities of my previous senior counsel as late as July 23. Have been assuring me that the said petition is pending as on this day also.
When you contacted, no date is given, July.
Yeah, exact date is not given.
Then what, when?
However, another advocate, I made inquiries, and my horror and disbelief, my writ petition has come about to be dismissed on 20th August 2015.
No, when did
I
you
was
learn?
not informed.
When did you learn about this dismissal? Date, again, date is not there.
That would be around in July, my lord, because that would be the date on which we have applied.
Can't be, Mr. It can't be presumption, right?
Exact date is
Like,
not
I mean,
recorded.
see, you should at least in specific terms say that on this date I came to know about dismissal. I was told by such and such person and then applied for certified copy and this. I mean, it's better you file an additional affidavit.
I'll file a better affidavit.
Learn it. Counsel for the appellant.
Please, my lord,
All right.
appearing for the appellants. And actually, the batch of 17 writ appeals were filed. And out of those 17, only
How much is the delay? How much is the delay?
240 days delay.
Heard on IA one of learned counsel for the appellants. What is the law? Just say something, right? If the court grants fine, doesn't grant obliged.
No, my lord, not like.
You know, you have
I
filed
am
the
aware.
application for
I am
condonation
aware.
delay 240 days. It has to be condoned first.
Apologies, my lord. I am aware.
Just I'm trying to take chances, right? If the court grants stay fine.
No, not at all.
Doesn't grant.
Not
Don't
at all.
twist it.
I'm sorry.
Don't do it.
Obliged.
Same order, right? Same order. Madam, item 4 also same order, notice on so and so, so and so. Personal notice, proof of service. List after respondents are served. Ah,
It is the orders of the Milord, particularly appellate tribunal, the present in petition is filed, Milord.
huh?
Milord, the petitioner, Milord, the auction purchaser, in pursuance of an auction held by the bank,
Ah,
Milord, the debtor, Milord, the approach the debt recovery tribunal, where he lost the, Milord, the application before the tribunal.
1 minute. Call Mr. Registrar IT or whomsoever. What is his? Huh? Ah, call him. Yes.
Milord, he purchased the property, Milord, in the auction held on, Milord, 2021. A sale certificate was also issued to him. Position was also delivered to him. Milord, while the sale certificate was under challenge before the tribunal, the tribunal refused to grant the interim order. Ultimately, the essay filed by the, Milord, the borrower is dismissed. Milord, the appellate tribunal interfered, Milord, on the ground. Before determining as a fraud account, no notice was issued to him. In fact, Milord, this was not the plea before the DRT or before the debt recovery appellate tribunal. That apart, Milord, the tribunal, Milord, record a finding of fact that the vehicle is not purchased and there is the GST filed by is a fabricated one. That finding is not interfered by the appellate tribunal. Therefore, my humble submission, Milord, when a fact finding authority finds that there is a fraud account, Milord, the notice is on an empty formality, but everything is concluded.
You know, will you not declare a fraud account after giving a notice? Or unilaterally you will decide behind the back of someone?
No, Milord, the tribunal, appellate tribunal said there was no notice to the borrower.
Did you
there
give
was a
notice?
under 13.2.
Did you give notice before declaring? That's Mr.
Milord, I am
That
the
is what?
Milord, I am the auction purchaser.
Huh?
I am the auction purchaser. Bank has not issued.
No, see. So is it your case that the bank had given notice? I mean, you.
Notice under 13.2, 13.4 issue. No reply given to that. 13.2 he received. He was an operation of 60 days.
You know that there is no answer, therefore you are deliberately,
Not.
not answering the query.
No,
This is,
sorry.
Mr. It is unlike an officer of the court. If you don't have an answer, say no.
No notice. No notice.
Then what is that Supreme Court decision Rajesh Agarwal says?
But not for that, Milord. The tribunal, Milord, gave a finding that he has not purchased the vehicle. It's a fraudulent transaction. That finding is not interfered. Therefore, Milord, what I subject to Lordship leave, Milord.
No, fraudulent transaction and fraud account.
Yes.
What is, have you seen, Mr. the judgment of the Supreme Court?
I find it, Milord. I find that copy, Milord.
Huh?
A judgment copy of the Supreme Court, I find it, Milord.
What is
The court says notice is mandatory.
that?
Milord, the bank already.
That is what?
Milord, the bank.
Then what can be done?
Yes, Milord. Subject to Lordship, Milord. The bank also filed WP number 26918 of 2023, Milord. Your Lordship order notice on the writ petition. Same order is under
WP
26918.
26918
of 23, Milord.
So you should have said no. That
Because
sir, it be heard along with taking chances that we will stay
No.
and direct handing over possession to you.
Position is
By way of an interim inter order,
Milord, the position
grant
has,
stay. So when we apparently did not agree, you then, why this? Mr. This is, you should be fair to the court.
I said so in the affidavit.
No, you first sentence that this be heard along with WP number because bank has already.
Yes. Milord, the position
No,
is-
since we were not agreeing, therefore you, this thing,
Not-
kept this, the, Mr. Strategy should be to put the best point first. Right? Not otherwise.
Milord, the position is already delivered to me. Milord, I filed the Panchanama also, Milord. Panchanama report also filed, Milord. Milord, the Panchanama is there, Milord. Milord, it page 165, Milord. It was delivered to me on 21/7/2022 property, my lord.
That doesn't make any difference, Mister. See, the bank has not heard the borrower, and that is the requirement. What is the citation?
My lord, the,
Supreme Court, 2023.
yes, my lord, 2023 6th SCC page 1, my lord.
What is the name of parties?
My lord, the State Bank of India and versus Rajesh Agrawal. I filed at page
Mark the
4.
presence heard on the question of admission. You want an order right away? Go to Supreme Court if you are. We are listing it. You said that we have to examine this, what order we have passed.
Yes, ma'am. Obliged.
Yes. Ah. Yes. Yes, Mister. What is illegal permission? What?
Permission from the general that
All right.
this filing counter now cannot be seen.
No notice has not been issued, right? Heard on the question of it.
Notice is issued, my lord.
Huh?
Notice is issued, which is at page 20.
Notice.
For the first time, it is coming, my lord. But to the petitioner, the respondent is issued notice is what I am saying.
Why have you this thing pleaded? Respond number 4.
Respond number 4. She was he said respond number 4.
So how is it? Your services have been terminated by R3, right?
R3 and R4.
R4,
Page,
how
30,
can, which
page
page?
30 and 31, your lordship.
The annexure?
31 R4 Millard, 30 R3 Millard.
How can there be termination of services twice?
Yes, Millard.
They have passed 2 orders.
Impugned proceedings. There are impugned proceedings on same date, Millard, 4/10/2020.
Page
30 and 31.
31.
Yes, ma'am. 30 is third respondent, Millard. 31 is fourth respondent.
How? That's what we want to know.
Yes.
Slightly surprising that
Yes.
2 orders.
Yes.
30.
30 is third respondent, Millard. 31 is fourth respondent.
31.
It's like this, my lord. Based on the letter issued by the third respondent to the fifth respondent, fourth respondent has issued termination order. This the 30 page 30
Both
my lord,
have
is
been
not, it's
challenged.
not addressed to the petitioner, it's addressed to the fifth respondent. Whereas 31 is addressed directly to the petitioner.
30 is the order passed by respondent number 3.
Yes, my lord. 30 is respondent number 3, my lord. 31 is respondent number 4.
This only, this thing. All right, yes. Heard on the question of.
My lords, item number 7, 8, 9 and 11 are similar, my lords. 7, 8, 9 and 11 are similar, my lords. My lords, this pertains to the Pollution Control Act air, my lords. Earlier, your lordships had passed, my lords. Earlier, notices were issued where composite orders issued by the third respondent, my lords.
Huh?
Here, my lords, on 21st June 2023, my lords, the composite order under pollution control.
Now it is under Air Act.
My lords, now it is only under Air Act, which I am challenging before this court, my lord.
No, so appeal,
My lords.
appeal,
Appeal.
Air Act,
What?
Madam, Air Act.
My lords, your lordship.
This is an order under section 31A of the Air Act.
Water Act is appealable to NGT is what this honorable court has held, my lords. I have filed order in WP 17179, my lords, at page 133.
Madam, this is an order under 31A, right?
Yes, my lords.
Ah.
My lords, if your lordship may kindly permit me, I will read the order in WP 17179 where this honorable court has held, my lords, that if there is an order directing compensation under Water Act, my lords, as there is a provision to go in appeal before NGT, the Water Act is appealable. Whereas under Air Act, as there is no statutory authority, appellate authority, the writ petition is maintainable. If your lordships may permit, I will.
There is no appellate authority under 31B,
My lords.
under Air Act.
No, my lords. I will.
Find out. Yes,
But
Mr. There is no appellate authority not designated.
But appellate authorities provision is there under both the acts, my lord. But what is
That we know, Mr.
Yes.
The contention is that there is no presiding officer designated as appellate authority.
currently they're not designated yet, my lord.
That is what your lordship has decided in this writ petition, my lords.
There is no question of deciding, madam. It's a fact, right?
Yes.
That it has
there
the
is-
moment, there's no question of decision. The moment he is designated, the decision comes to an end.
No, my lords. My submission is, my lords, even if there is a provision to have an appellate authority, there is no appellate authority as such in existence. Whereas, Honorable Supreme Court, my lords, your lordship may kindly allow me to read, my lords, page 140 of the order, my lords.
Yes. Which annexure, madam?
Madam,
Annexure.
page 136.
Annexure.
Annexure is 14, my lords, 1-4. I'll read the relevant para at para 8, my lords.
Page 140.
138, para 8.
138.
My lords, here your lordship, this court only, my lords, has referred to the judgment of the Honorable Supreme Court, observations made thereunder, my lords, wherein the learned counsel before Honorable Apex Court had submitted, my lords, that Water Act has the appellate authority and therefore it is appellable before NGT. Air Act, even if there is appellate authority and there is no authority constituted, the NGT has the appellate acts as an appellate authority. Whereas this Honorable Supreme Court, my lord, has held that it is out of the jurisdiction of NGT and as such, the writ is maintainable, my lords. I'll read the relevant paragraph, my lords, if your lordship so permit, my lords. We have referred to the orders, my lords. I'm reading page 139, my lords. We have referred to the orders dated 12/4/18, 23/5/18 and 28/5/18 passed by TNPCB under sections 33A and 31A of the Water Act and Air Act respectively. At this juncture, it is important to state that section 33B of the Water Act and section 31B of the Air Act were both enacted on 18/10/2010 which is very date on which the NGT Act came in force. What is important to note is that whereas Section 33B(c) of the Water Act read with Section 16(c) of the NGT Act makes it clear that directions issued under Section 33A of the Water Act are applicable to the NGT. Directions issued under Section 31A of the Air Act are not so applicable. In fact, the statutory scheme is that directions given under 31A of the Air Act are not applicable. This being the case, all the aforesaid orders, being composite orders issued under both the Water Act and Air Act, it will not be possible to split the aforesaid orders and say that so far as they affect water pollution, they are applicable to NGT, but so far as they affect air pollution, a suit or writ petition would lie against such orders. Sri Sundaram's
No, what, madam, then you see 31B,
My lords.
31B of the Air Act.
My lords,
You are read first. You are just, I mean,
no, my lords.
read 31B. Read it for, we have not read it, madam, for us, please read it.
No, my lords, I am not intentionally avoiding this.
No, please read it.
31B, I didn't have it.
Huh?
Only 31A is. It's not intentional. My apologies, my lords. Appeal to the National Green Tribunal. Any person aggrieved by an order or decision of the appellate authority 31 made on or after the commencement of the National Green Tribunal may file an appeal to the National Green Tribunal established under Section 3 of the NGT in accordance with the provisions of the Act. My lords, this court, my lords, one submission, my lords. This court, my lords, in this, those same orders were challenged in WP 18057, my lords. I have filed the order at page 130, your lordship.
That was a case of a composite order, madam.
Yes, my lord.
This is Supreme Court. The court placed reliance on a Supreme Court decision to say that in case of a composite order passed under Water Act and Air Act, the petitioner cannot be relegated because one part of the remedy is not applicable. Here, the case is under the Air Act, and you have seen 31B.
My lords, if your lordship so permit, my lords, I'll try to satisfy this court. My lords may have it tomorrow, my lords. I'll satisfy the court on this point, my lords. I'll go through it again, my lords.
You have seen it, madam.
Much obliged.
You have seen the provision.
Yes,
Take recourse to it. It's not that you are remediless.
My lords.
Take recourse to the remedy. Yes. Write down. 7. Oh, it was initially not working, that's why. It should be little higher, a little higher, right? I want little up. Now, let it be after in the break you do it, huh? Little, yes. Okay, then, fine. Yes. Ah.
Wait,
Ah.
within this. But in this matter, we've received instructions from it. There was a Form 7 file for deletion within a period of relevant correct period of time. That form was, my lord, filed with the booth level officer physically, which booth level officer, my lord, inadvertently forgot to put it up online, and therefore it did not get processed. Time period has lapsed since then. My lord, action has been taken against booth level officer to call for a show cause notice. The explanation was given. Explanation was not found satisfactory, but a warning has been given. But the contention of the petitioner is his name is appearing in two booths. One is in Bodhan, one is in Nizamabad. He is a voter in Bodhan. My lord, the reason why they cannot now process the Form 7 application is the mother roll is already prepared, my lord, for the elections. Supplementary rolls, my lord, will have the additions, etc. There is another supplementary roll called absentee shifted dead voters. In that roll, my lord, his name will be put as, my lord, shifted voter. Therefore, my lord, he will not be in a position to vote in Nizamabad. It is essentially as if, my lord, his vote is not there in Nizamabad, which will be affected. And, my lord, he can vote in Bodhan. But the solution is found.
Your
So the mother roll is prepared.
grievance stands redressed now, right? Huh? Yeah.
Kindly record the same and pass.
It doesn't show, see. It starts with restriction only.
2 copies.
Uh,
Instructions.
It is.
Acha, cool.
Huh? Yes.
May record the same and
Yes, that's what we are. Yes. Mark the presence with consent of the parties matters heard finally. In this writ petition, comma, the petitioner inter What? Wait. In the beginning, you write with consent heard finally.
Deep leverage.
My lords, AG is
Milord, I beg to appear for the respondent writ petitioners, Milord. These writ appeals are filed by the state.
My lords, AG is appearing, my lords. He is recuperating from flu, my lords. He requested next week, my lords.
My lords, may kindly see, my lord, the proceeding sheet itself shows your lordship has given a lot of indulgence to them.
Well, not well, no. You heard him. What we would. Yeah. What's your name, Mr. Learned
Bharti
Counsel submits that the Mr. Counter not filed in your case. Mr. Why?
Just 1 week time for filing contest.
You have to file counter, no?
I will ask next Wednesday time, we'll file.
Order sheet.
That very simple matter
Yes.
requests
we know.
time for filing a counter.
Yes.
All 16 are on record now.
My lordship, I filed wakalat on behalf of
Our grievances, we remember, Mr. Rao, that the candidates who have participated in first 3 phases of counselling have been allotted seats in this thing,
Stray
stray round of counseling. Simple.
Yes.
Why? No, whatever, Mr. You
But
have to respond.
Since I sent notices to all these 16 respondents, a very amusing situation now for me.
Why?
They are targeting me, they are calling me and asking me, how the hell did you get our addresses and all? And how are we dragged into this mess now? They are so shocked and surprised. How did we ever? We did not apply, we did not participate, anything. They just simply, the 16 candidates who already got in the first 3 rounds now have been shown without any participation from them. They say to me as a counsel, because they received my personal notice, which has my number, they expressed shock to me.
Why?
We did not participate. How did the university allot us a seat in stray? We never asked them.
So they are not taking admission. Then that's the end of your.
No, they have been slided into that category in a stray vacancy round.
No, but it is. If they did not participate, they are justified in refusing to seek admission. They can't, nobody can compel them.
No, they have been already admitted in first and second round. All these meritorious candidates.
So these candidates, according to you, are not taking admission, right? So then grievance does not survive.
No, I did not mean that. But they have already been admitted in 1 and 2.
No, we have got it, Mr. Rao. Your submission is that these private respondents are supporting your case. And they are saying that we have wrongly been allocated seats in a stray vacancy round. Get them, make them to file a counter. We will decide, we will dispose it off. Then nothing survives.
One fact from the central agency, my lord, the MCC, DGHS.
So let them say that same thing which you are saying. We will right away dispose of. Yes, Mr. You are appearing for private this thing.
Private respondent number 18, Lordship.
Then what is your stand?
Lordship,
You are not seeking admission against.
I already joined, Lordship. I am already joined.
They already joined.
Then that's the end of the matter. We can dispose of. Why does this thing keep it pending? Right? Who appears for 18 and who else?
And for 12, my lordship.
You are also not taking admission
No, ma'am.
against the seat offered you in stray vacancy round, right? Right. We'll record their state. Who else?
Already we were allotted seats in phase 1.
They have been allotted in phase 1 and phase 2.
R10 and
R9 and R16, my lords.
R9 and 16. But how to? She also said 16.
No.
12, sir. 12.
12.
Number 21, my.
And
21. 21.
you are also not taking admission.
We already joined, Lordship, in phase 2 counseling.
We already joined in phase 1 counseling.
All right. Yes. Mark the presence. Then why have you allotted? They are not taking admission. Grievance stands redressed.
No, my lord. See, they have been allotted in phase 1 and phase 2, my lord. They did not participate in the further rounds. These 16 candidates, they did not make registration and they did not exercise web option.
Please appreciate that these candidates who have been allotted seats in stray round of counseling, they are not taking admission against the seats allotted to them in stray round of counseling. Those seats are vacant. Now, whatever it is to be filled up will be filled up.
If their allotment in stray is cancelled, they'll go back to their allotments in phase 1 and phase 2. That's my submission. If their allotments in stray vacancy round is cancelled by the university now, they'll go back to their allotments in the first phase and second phase. That should be the case, my lord.
No. So if they are not taking admission, the seats become vacant, right? In any case, Mr. Let them file a response. Then it's better. Then they will say that we did not mean this. You are also not clear. We are also not clear. So better to get everything in writing, right? So learned counsel for us.
But Monday, your lord. Monday.
Tuesday. 7th. Tuesday 7th, no?
But an important respondent, the DGHS also has to file a counter, my lord.
We have granted what to
Yes.
do? We have granted them time 7th November. Yes, 17th same order. You had to file reply to
I have filed reply. Not
learned counsel for the petitioner. Petition is admitted for hearing, you say. Okay, 20.
These matters pertains to the medical college elevation.
They have to go before some other bench of which brother is.
The pleadings are completed. Lordships are otherwise directed for the, I understand, my lord.
Let the writ petitions be listed before a yes. What the appeal has been, petition has been admitted, Mr. Prabhakar.
This is actually to consider the objections of the petitioners only, Milord. Similar circumstances, this honorable court was pleased to pass the order. Your Lordship may kindly consider.
Petition has been disposed of.
Yes, Milord. This honorable court was on 8/8/2023. Yes, Milord.
Yes, Mr.
I am appearing on third and fourth respondent.
This is the order, right? You have, he doesn't have a copy.
Consider the objections of my which were submitted before the third respondent.
Same order, right?
Same order, Milord. Your Lordship, great respect to this honorable.
Oh. All right, yes.
This matter, my lord, is a AP special GP appearing in this matter. AP special GP, my lord, Govardhan Reddy is appearing in this matter, my lord. I am appearing only first and third, fourth respondent.
What do you say with regard to the, why are you holding a brief for a person who doesn't want to appear? Huh?
His Lordship in his
Huh?
objections was the invited minute, third respondent. Third
Same order.
respondent.
Disposed of. All the
So-
three matters, Mr.
Two matters same.
27,
7 and 29.
29. What happens to 28?
28 is not mine.
You're not, but it is tagged with you.
I'm
Yes.
deeply oppressed.
28.
May I please, my lord?
Okay, third party file implete petition, I file my
Huh?
counter, you ask my kindly grant 2 weeks time, my lord.
Huh?
Third party file implete petition in my case.
Yeah.
I'll
You
file
want
my
to file counter?
Yes.
Done it counter.
For the, sorry, Millard,
Fine.
one submission, Millard. Before vacation, Millard, the
Huh?
connected matters, Millard, the similar.
Hey, Mr. We fail to understand, right? 1 minute. We fail to understand if you want some relief for yourself, why don't you file a petition impleading in somebody else's petition? What?
I'm
He is
filing-
entitled to his petition. You are trying to intervene. So he has a right to file a counter. So we are granting him
I
time.
filed
What?
the complete petitions, Millard, and vacant petitions, Millard.
He is,
Before vacation, the
I am
Millard,
challenging
this-
my allotment order, but he is no way concerned with it. Anyhow, I'll file my counter.
the similar case, Millard, the heard both sides, Millard. They take short time, Millard, for filing counter, Millard. These are connected matters, Millard. Kindly post along with the.
In my
connected
case, it
along-
is not there.
The batch cases are
But-
connected.
No. What is this, Mr.? You will not allow him to even prosecute the writ petition. Is a constitutional right.
Yes, yes.
Getting it tagged with somebody, impleading. Or why?
They are the
Who are
affected
you?
party, Millard, so.
Let him. We will decide after he
Yes, yes.
files a counter. Let him file.
Kindly post along with.
No. Then later on people say that it is not tagged, and then we have done it yesterday. Previous date council said that it is not tagged. Then yesterday the council sought an adjournment on the ground that those matters are not listed. This is
Sorry,
don't
Millard,
take.
we are the affected
We
party,
will
Millard.
no. This is we are watching your conduct. We will take serious exception to this. You file an application for tagging.
2 weeks.
Nobody takes the responsibility of statement.
2 weeks are always over, Millard, prior to vacation, Millard. The
2 weeks
similar
are
matter,
over?
Millard, they are start time for filing counter, Millard. Already 2 weeks hours,
They are no
Millard.
way affected.
So
In fact,
kindly
in my case,
tag the
I
along with-
challenge my allotment orders to different zone. And there are several interim orders have been passed around. How is he concerned on the way he implementation is there? He is no way.
He wants to be posted in your place, and therefore he wants that you should be relieved to state of Andhra Pradesh so that post becomes vacant, and then he must have been assured that he will be posted in your place. You file it.
Very well.
When he was granted time.
Sorry, Millard, apologies, Millard. Kindly tag the similar.
No, Mr. If you want any tagging, file an application and own the responsibility. Then people say that I did not make this statement before the court. The court on its own has tagged. Why? Why it should be tagged?
They filed the implead and the vacant petition, Millard.
Huh?
We filed IA 2 and 3,
You
Millard.
tell him, Mr. He is not understanding.
I'll-
How-
2 weeks, not I'll file.
Few dates.
Oh, so nice. We have got this.
Dates, your lordship, and you.
Huh? See, I told them to get this interim order also. They have not got it. Good. You have noted them.
Prepared the list of important dates, your lordship.
Given few dates, your lordship, given the dates of synopsis.
You have given us yesterday a synopsis, right?
That is given by the respondents,
Huh?
your lordship. That is given by the respondents. I prepared the important dates.
Yesterday you did not give us any synopsis, right? This is your synopsis. Yes.
Yesterday I was reading the counter of the THMC, your lordship.
Hmm?
And in this, I have filed the counter of the big petitioners.
Given the entry market. Yes.
Along with this, your lordship, I filed the counter filed by the writ petitioners before the government. It's at page 2, your lordship. Nowhere in this counter, your lordship, he has stated that this petition under 679 is not maintainable.
No, go ahead, madam. We are listening to you.
Sorry.
Don't look at us.
Sorry. Nowhere in this counter before the government has stated that this petition under 679 is not maintainable. And he went on saying that he has, his title has been declared in the earlier suits, which has been filed between the AP Waqf Board and himself. The judgment, your lordship, during the pendency of the writ petition, when we filed a vacate stay petition, your lordship, that was heard, and as he was going on with the construction illegally on the basis of the injunctions obtained by him in the suits, order was passed, your lordship, in WVMP 108, that can be seen, your lordship, at page 14 of the judgment. WVMP 108591 of 2007.
Which one?
It's a day that was allowed on 13/7/2007.
Must be there with three.
Wherein this honorable court
Must be there. Yes.
has
It will be annexed.
directed the authorities not to give water connection, electricity connection, and directed the GHMC not to give occupancy right certificate. This is retained
This is the order.
by the
Page 54. No, not 50. Which page is the judgment order of the learned single judge, madam?
7. It starts from 7, your lordship.
7.
Here the prayer is proceedings 9/5/2005. When the final order is 3/3/2006. As such, now they filed an amendment petition, your lordship.
Seven. There's no, not there.
The learned single judge extracted the affidavit.
Where is the order, Mr. By learned single judge?
Seven.
Huh? Page 6. Ground 4. Hmm. 6. Yes. Which page you are referring to, madam? Order of the learned single judge?
Page 14, Your Lordship. Internal page 8.
Internal.
If there is some discrepancy in the minutes. Here, Your Lordship, interim directions on the basis of our vacates petition, orders were passed on 13/7/2007, directing the authorities, Transco authorities, not to give permanent electricity connection, and GHMC authorities not to give occupancy right certificate, and all water connection and sewerage connection is directed to be restrained. So this has been continued with the last para of the order, Your Lordship, in spite of setting aside the impugned order. But here, Your Lordship, at page 6, the impugned order, they have mentioned it as government memo number 23943 by M1 by 2003, dated 9/5/2005. When the final order was passed by the government on 3/3/2006. As such, now they have filed an amendment petition for amending the date. This 9/5/2005 is the notice.
Ask her what are the grounds of challenge.
What are your grounds for challenge?
That single judge, Your Lordship, has not even gone into the amendments, my amendments into, and they did not take that into consideration and has passed the orders only on the basis of the affidavit of the writ petitioners and has dismissed the allowed the writ petition, setting aside the orders dated 3/3/2006. But though they said impugned order is 9/5/2005 there. And this, he has taken the judgments between other third parties. Yes, mentioned it, tabular column, Your Lordship. Wherein at page 29, internal page 23, he has taken the judgment copies of the.
No, madam, won't it be better if you tell us this is first ground, this is second ground, this is third ground, and then elaborate? You are reading here and there, you gave us this synopsis, and you are reading interim order at page 6. What do we get out of it? I mean, I don't know.
Here, Lordship.
Please tell us what are the grounds of challenge 1, 2, 3, 4, and then perhaps you can elaborate. We have understood, right, that he had applied for building permission previously, that was not granted, again applied, and then it was granted, then you filed a revision. Your ground of revision was that he did not file the title deed along with his application for grant of building permission, which is the requirement, and therefore the revisional authority has rightly set aside the order, and the learned single judge erred in interfering with the order. On what grounds?
Yes, Your
So that you should tell us instead of your reading. Reading doesn't make, you can continue reading this. It doesn't make any sense, right?
Though the government has rightly pointed out, Your Lordship, that they have not applied the permission with the statutory documents which they have to be annexed and set aside the building permission, the learned single judge did not go into that aspect at all. And I stated that I have filed the application after 14 years of grant of permission, and as all the judgments in the lower court, that is between third parties and the writ petitioner, have gone against me.
Please go to the findings directly at para 14, 15 and 16. You have filed a suit after construction. You have withdrawn the suit. You have
That's
filed
what I'm
a-
saying, Your Lordship. Permission is granted of,
See the findings, madam.
permission is granted in 1992. And the suit which he referred to is filed in 1994.
Who filed the suit?
They filed a suit for permanent injunction. That was decreed ex parte. And he takes that into consideration and says that as I have
No, no.
lost
During the
all the
pendency
cases.
of the suit, you have completed the construction.
No, I am not the I am asking them to stop construction. The writ petitioners have raised construction. On the basis of injunctions they have got in the suits filed by them against THMC.
No. That's not.
Building permission was granted to the writ petitioners, Your Lordship. That was challenged by the third respondent.
And that order was challenged by them, the reputation has been made. She's been appealed.
Building permission is granted to the writ petitioners. That was challenged by the third respondent.
We know that.
And I have not raised, I am against their construction. That
No, we are asking you what grounds you are challenging the order passed by learned single judge again, second time, madam, this morning. You are not telling us what ground.
Your Lordship, permission is granted in 1992.
First of all, you will have to tell us what ground the learned single judge has allowed the writ petition. Then only you can challenge those.
Yes.
What has learned single judge held? Tell us.
Learned
Why it has been crashed.
that I have filed the application after 14 years of grant of permission.
So,
And he has just ignored the statutory requirements.
no. So for you have filed 14 years, therefore writ petition is allowed. This is the reasoning.
Your Lordship, may I kindly see? So he says at page 31, Your Lordship. Page
All right,
31.
madam, proceed in your own way. We will not intervene. Proceed. Feel comfortable. You argue. You have a right to argue. You argue in your own way. We will not put any question. Proceed at the manner you want. Yes.
This permanent injunction suit on which the basis of which the learned single judge has stated that I have lost all the cases before the lower court is not the title suit, Your Lordship. It's not a title dispute. And he claims that he is the owner on the basis of that permanent injunction suit and claims that he is, I have lost all these cases. All these cases, Your Lordship, may kindly see, they are filed against, not against me. He has filed against Work Board and other parties, and I was not party there, except 510 of 1994. It's only permanent injunction suit, and that cannot be declared as a title suit. Though the court learned single judge, Your Lordship, exacts that in the government has stated that he has not annexed the documents which are statutory and mandatory to be annexed along with the application as per section 429 AA and as per bylaws. He never says he has filed the documents whatever are available with him at page 31, Your Lordship. When there is a clear finding by the government in the memo stating that the documents which are to be annexed along with the building permission are not annexed, the learned single judge says the first petitioner has submitted what all the documents available with him in order to substantiate his claim over the property. That is not the statutory requirements which are mandatory, Your Lordship. And they take and say, as the commissioner has granted permission in contravention of the statutory requirements, the government has rightly set aside the building permission. After going through all the original records, and the learned single judge also states that the consent has been taken into consideration. Consent for not claiming compensation for the land which is coming under road widening has also been considered and building permission is granted. The learned single judge never went into the statutory requirements also, but he has not even discussed. Though the learned single judge came to a conclusion that construction itself is bad and against the statutory regulations, and a notice under 452 of HMC Act has become final, he has given them errata, Your Lordship, saying that construction's status quo to be maintained till the regularization application is disposed of.
One of Andhra property construction is being raised.
And only one para, Your Lordship. Para 14, Your Lordship. Para 14,
Please
Your
argue,
Lordship.
madam. Please argue.
14, Your Lordship.
Please argue. Why don't? We are entitled to look at the file, right?
Yes, Your Lordship.
Please go ahead. We are listening to you.
Para 14. Keeping in view of the findings recorded by the civil judge in civil court, the question for consideration is, this is the question he has framed, Your Lordship, whether the order passed by first respondent purporting in exercise of powers under 429 AA of HMC Act 1955 and Municipal Corporation Bylaws 4.25 can be allowed to stand, and the petition who constructed the building under the guise of interim orders can be permitted to use by themselves by his parties. Powers are exercised under 679.
In micro instance, after the period of 14 weeks, building and we have also directed these people are this construction will land of income, therefore they cannot be permitted to occupy till regularization is made. This now she's saying there's no decree. There is no decree in your favor from any civil court saying that you are the owner of the property, right?
There is no decree in his favor, your lordship, that he is the owner.
Your favor we are asking.
I am the owner. My title is not questioned at any time. And in fact, your lordship, the building application.
Please understand the query, madam. Unfortunately, we have to write judgment, right?
I know.
Unfortunately, for the parties.
I am here only to assist your lordship.
So unfortunately, so therefore, please answer the question. Is there any decree by a court declaring title in your favor? No.
There is no decree also declaring their title. This is not, he has not filed the statutory mandatory documents along with the building permission.
That is understandable.
And
that we have
29.
Merely because we are hearing you with patience, that doesn't mean that you will keep on repeating. It's not that difficult case. We have understood what is the case. You have told us yesterday also, we heard you for half an hour. Today also we are hearing what can be done.
And only the point the single judge has framed is whether the order passed by the first respondent purporting it in exercise of the powers under 429. 429, the government has not exercised the powers under section 429 AA. The government has exercised the powers under 679. That's a revisional power, your lordship, and government has come to conclusion that they have the building permission is granted contrary to the statutory regulations, as they have not annexed the documents as stated in 429 AA. The very consideration itself is wrong. Power is exercised under 679 and not under 429 AA. And having come to conclusion, he has raised construction illegally only on the basis of the injunctions taken by him, and those section 452 notice has become final for demolition. The learned single judge has passed the order setting aside the orders of the government. In fact, your lordship, even this, they have claimed, mentioned 9/5/2003 in the main inspection. They have not questioned the orders passed by the government. That's the final orders passed by the government on 3/3/2006. As such, they have filed an amendment petition, that's IA 1 of 2003. I filed a counter clearly stating that the petition itself is not maintainable, as the council who has filed the petition does not hold wakalat for the fourth respondent. And after 17 years of filing of the writ petition, your lordship, they have filed this claiming that it's a typographical mistake. As such, that amendment petition is liable to be dismissed. The single judge has not even gone into the proper case properly, your lordship, and has taken all the averments of the writ petitioners into consideration and has set aside the orders. So when the statutory authority has passed orders considering all the original records, now they cannot claim, your lordship, the petition under 679 is not maintainable. They have not taken that stand in before the government at all. As such, the writ is liable to be dismissed.
That's it.
In fact, the judgment is also there, your lordship, of this honorable report, that the 679 by an individual is maintainable, which I have already given a copy in the
Which?
This is a USR for 55900 of 2003.
Huh?
Earlier I have given this, your lordship. Brief notes was given earlier. This is the USR 55900.
We asked you previously, you gave note, you said no. I am giving now. This is
No,
the
this
note
is,
given.
no, this is the dates which I have given your lordship specifically. Dates of important dates. And earlier, another,
What?
the USR.
Will you tell us the citation?
Yes, you.
The learned single judge has not said that it is not maintainable.
It is maintainable.
Yeah.
That is WP 23972 of 2003, your lordship. This is
No,
2004 1
Where
ALD
is the finding that it is not?
49.
He has not said that.
He
It
has
is not
not
maintainable.
said anything about that.
Pardon.
The learned judge has not expressed any opinion on that.
Yes, your lordship. But learned single judge has not even gone into.
No, you are laboring on a point which is not decided against.
No, they.
Learned single judge has not held that it is maintainable, not maintainable.
Yes, but the other side.
He has decided it on merit. Huh?
Other side were arguing about this as not maintainable.
I have not argued as yet, madam. You will have a right to rejoinder. You will please know what they argue, then reply.
Because earlier this was argued, your lordship, as such I have.
We don't know what was argued earlier. I was not here. My brother was also not there. We don't know what was argued. You will have a right of rejoinder. You want to rely on any judgment, please tell us. What judgment?
I've submitted copies. I get the copies, your lordship, because
At least you need to tell us, madam. Submitted copies means who will find it out? Please tell the citation.
This honorable court has stated illegal constructions cannot be legalized. That's citations, Manupata citations there, your lordship. Manu AP 0493 of 2022. That's WP. It is with regarding to this building.
Give us a copy. What is that Manupatra?
This is setting aside the.
It is not reported anywhere else except Manupatra.
It's not. Usually that will be given. That's not given, your lordship. That's the change. This is the where this honorable court has
at least
set aside the PRS scheme, your lordship, earlier. The GO was set aside. And
Please appreciate you are under an obligation to supply us a copy. Or should we find out it's an unreported decision? You are not telling us citation. You are just saying this has been done, that has been done.
Submit the copy.
What like?
I'll submit the copy within half an hour.
You are appearing for?
My lord, I am referring to the parties as they are arrayed in the writ petition, my lord. I am appearing for the first petitioner in the writ petition, who is the third respondent in the writ appeal, who passed away. My lord, his LR has been implemented as fifth respondent in the writ appeal.
I appear for the fourth respondent, my lord. Developer. I'll make my submission after Senior Counsel Srinivas next.
My lord, I submit the basic facts and also then, my lord, I may submit what are the contentions that arise for the consideration of the honorable court.
Yes. Yesterday we were given a synopsis, right?
Yesterday, my lord, a synopsis was given.
Yes, madam. Yesterday. Facts like
yes.
Yes.
My lord, the basic facts are like this. My lord, building permission was granted by the GHMC in favor of the writ petitioners.
No, they are referring to this 8/12/69 whatever.
Yes.
No, this is not, madam. Yesterday, counsel for respond number 5 gave. Yes.
Yes. But I was submitting the
dates, my lord, should have synopsis.
Yes, Mr.
Yes. My lord, 5/6/92 was the date on which the building permission was granted.
5/6/1992.
Petition was filed by the third respondent in the writ petition before the government under section 679 of the GHMC Act my lord, on 19/12/2003, after more than 11.5 years. Then government passed the
2003,
my lord, after 11.5 years. Then government passed the order impugning the writ petition on 3/3/2006, setting aside the building permission granted by the municipal corporation, which was challenged in the writ petition, my lord, which has been set aside by the learned single judge. My lord, the three legal contentions that may arise for the consideration of the Honorable Court are: one is whether that 679 provision is a suo motu power, my lord, conferred upon the commissioner, whether it can be invoked by a third party also seeking, my lord, setting aside of the building permission granted by GHMC. My lord, that is the first question that calls for consideration. But second question is, even assuming for a moment, my lord, a third party can also invoke the power of the government, whether the government can, my lord, exercise that power at any point of time, even after, my lord, of 11 years or so, or it has to be exercised in a reasonable period of time. Third question is whether the third respondent in the writ petition has made out his locus before the government for, my lord, invoking that power and seeking cancellation of the building permission. On the first question, my lord, I can see the power conferred upon the government under section 679. It reads like this.
$679.
The government may, at any time, for the purposes of satisfying itself as to the correctness, legality, propriety, or regularity of any proceedings of or order passed by the commissioner or any officer subordinate to him, call for and examine the record, shall pass such orders with reference thereto as it thinks fit. Well, it says it is a suo motu power conferred upon the government, my humble submission, and my lord, it is not a power because, my lord, the statute sometimes says the government may, or on an application made by a party, my lord, can call for the records of the lower authorities and, my lord, examine whether correct or not. Whereas here, my lord, the language is government may at any time for purpose of satisfying itself may call for records and may decide it. My lord, my submission is that a third party cannot invoke this power of the government. It's only suo motu power of the government. In this case, my lord, the third party, that is the third respondent to the writ petition, has filed an application. Government took it as if it's an appeal, and my lord, went on ultimately passed the impugned order. I rely upon a judgment of the Honorable Supreme Court, my lord, reported in like AR 1994, Supreme Court, page 2377. This case arose under the AP General Sales Tax Act. That act also has got a section which empowers the commissioner, my lord, to suo motu call for the records wherever he feels that, my lord, the order passed by lower authority is prejudicial to the interest of the revenue and can, my lord, either set aside or modify or amend and do anything with that. My lord, in that context, what happened was an SSC who lost before the lower authorities has invoked the power of commissioner under section 20 of the act, and my lord, commissioner passed orders in his favor. That matter went, my lord, before the Honorable High Court and also before the Honorable Supreme Court. Then the Honorable Supreme Court has held that the SSC cannot invoke this power. It is only a suo motu power granted to the commissioner, and SSC has got various other remedies like
the provision is similarly worded. No.
Similarly worded, my lord. And you see page 2, paragraph 3, the lordships have extracted the section. Section 679 also says government may at any time for the purpose of satisfying itself to correctness. Whereas the section 20 of the AP GST Act extracted in paragraph 3, revision by commissioner or commercial tax and other prescribed authorities. Commissioner of commercial tax may, suo motu call for and examine the record of any order passed or proceeding recorded by any authority, officer or person subordinate to it under the provisions of this act, including subsection 2. If such order proceeding is prejudicial to interest of revenue, may take such inquiry to be made subject to provisions of this act, may initiate proceedings to revise, modify or set aside such order or proceeding and may pass such order so it's so. My lord, the lordships of Honorable Supreme Court have held that, my lord, it's only a suo motu power. A third party or SSC cannot invoke such a power.
No, but this thing, the difference being that in section 21
Yes.
of Andhra Act, the word expression suo motu is
Suo
there,
motu is there.
which is not there in
It is not there. It
679.
is not there. But my lord, power is confined only to the commissioner. My lord, it says at any time the government may, for the purpose of satisfying itself. It is, my lord, equivalent to suo motu, my humble submission. So, my lord, as per this judgment, SSC can avail.
Which para?
My lord, paragraph 4. The question. The question whether the SSC has a right to make an application for the exercise of suo motu power by the commissioner calls for consideration in the light of the other provisions of the Act, expressly providing for a right of appeal to the SSC. Under section 19 of the Act, a right to appeal to the appellate authority against original orders or proceedings of certain authorities has been given to the aggrieved dealer. Section 21 also gives a right of appeal to the aggrieved dealer to the appellate tribunal, postulating that any dealer objecting to an order passed or proceeding recorded by any prescribed authority on appeal under section 19 or 22 may appeal to the appellate tribunal within 60 days from date on which the order of proceeding was served on him. Thus, the statute itself has given a right to dealer to object to an order passed or proceeding recorded under the Act, which is prejudicial to him, by filing appeal against such order under section 14 or 19 or a revision under section 2 of the Act to the appellate tribunal. As stated against the original order, appeal shall lie to the appellate authority within a period of 30 days from date of receipt of the notice served on the dealer and further appeal to appellate tribunal. Order under section 20 would also be appealable again to the SCAT by the aggrieved dealer and a further revision to the High Court under the Act. Thus, the Act has given right and remedy of appeal or revision to a dealer whenever it is intended, as seen section 20 as suo motu revisional power exclusively given to the commissioner or joint commissioner or the deputy commissioner or commissioner tax officer, as the case may be, to revise the orders or the proceedings of the officers subordinate to the respective officers. Whether suo motu power under section 20 could have been invoked by SSC is the question. Then the lordships are referred to the judgment of a privy council, wherein also similar question has arisen. Extracted portion at the bottom of that page is the judgment of this Privy Council judgment. Then, my lord, paragraph 5. The High Court of Andhra Pradesh has occasion to consider the scope of section 20 of the Act in 2 of its judgments. In Kalluri Bhimalingam, the SSC has sought to file an appeal to High Court under section 23 against the order of the Board of Revenue. At that time, revisional power was exercised by Board of Revenue, revising the assessment under section 21 of the Act, which the board has rejected as being not maintainable. High Court upheld the order of Board of Revenue, holding that section 20 of the Act does not provide a right of revision at the instance of SSC, but only provides suo motu power of revision to the Commissioner, and under section 23(1), a revision does not like the High Court against the order passed by the board. Therefore, the appeal was held not to be maintainable. Same view was reiterated in the Sri Ramachandra Ginning and Oil Mills. So it must therefore be held that the validity of assessment order must be tested in an appeal or revision filed by an SSC as provided for the Act and not in other way. The SSC cannot invoke the suo motu power of the authorities under section 20. Any order validly made does not become void or illegal by subsequent declaration of law. Suo motu power was conferred on higher authorities to correct errors of law or to correct improper or irregular procedure or illegality in the procedure to safeguard the interests of revenue, so as there was no express power given to state to file an appeal against the order of assessment. Then, my lord, paragraph 7, because in that
case one, third party interest. Here it is between the commissioner and the SSC to see the validity of the order. The question is whether the power under 697 is a suo motu power. The suo motu is that word is not that I told you that's a submission that we have to consider.
next point is, my lord, whether it can be exercised by the government.
So your submission is that power under 679 is a suo motu power, can't be invoked by a third party.
Third party, yes. That's the first submission.
But 94 Supreme Court slightly.
Yes.
I mean, it was clear-cut case because the provision itself says suo motu where it is not.
Suo motu word is missing here.
Missing.
That is true, my lord. But my submission is, my lord, this also a suo motu power only.
But
Though the word is-
any other provision Supreme Court must have considered like similar provision.
No, in that judgment, no other provision, only that provision.
No.
Yes.
There may be any other judgment. We don't know.
My lord, yes. The second issue, my lord, that I submitted to lordship is, even if such a power can be invoked by a third party, can it be invoked at any point of
any
time?
time.
Yes. My lord, for that I rely upon 2007, 11 SCC,
2007,
2011, 7 SCC, 363,
2011.
2011,
7 SCs.
2007, my lord, I'm sorry, 2007, 11 SCC, 2007, 11 SCC, page 363, 363, paragraph 18 onwards. My lord, in fact, those judgments were passed on the last occasion, my lord, when the matter hearing took place. They must be there in the file, my lord. I may be permitted to read it, madam. Yes. Para 18, it is right that if no period of limitation has been prescribed, statutory authority must exercise its jurisdiction within a reasonable period. What, however, shall be reasonable period would depend upon the nature of the statute, rights and liabilities thereunder, and other relevant factors. Revisional jurisdiction, in our opinion, should ordinarily be exercised within a period of 3 years, having regard to the purport in terms of the said act. In any event, the same should not exceed the period of 5 years. The view of the High Court thus cannot be said to be unreasonable. A reasonable period, keeping in view the discussions made hereinbefore, must be found to be out from the statutory scheme. As indicated hereinbefore, maximum period of limitation provided in subsection 6 of the Act is 5 years. Then, my lord, let's discuss about the various cases in which what is the reasonable period has been discussed. And accordingly, my lord, their lordships have held. Maximum 3 to 5 years would be the reasonable period for exercising suo motu revision power, even where the statute doesn't prescribe any period of limitation. Yes. My lord, on same lines, another judgment 2018, 7 SCC, 346, para 58 onwards.
Yes, settled.
That's also on same lines. So that is the second submission. Third submission is, my lord, that will the government be able to exercise such power at the instance of a party who doesn't make out his locus standi before the government? Because, my lord, a passer on the street, my lord, cannot question my building permission. I mean, even within the reasonable period of time also, leaving alone, my lord, without the reasonable period of time. In this case, my lord, how the government proceeded, lord, may kindly see. I refer your lordship to the paper in the writ appeal. Government order starts at page 45. Order dated 6/3/2006. It's a short order, my lord. I'll read out. Reads like this. In the reference first cited, Hamiduddin Ahmed has filed a revision petition before the government with a request to quash the permit number so-and-so dated 5/6/1992 issued by the Municipal Corporation of Hyderabad in favor of Mohammad Muniruddin, third respondent to the revision petition for construction of building in the premises number so-and-so, Bashirbagh, Hyderabad, alleging that the same is illegal, arbitrary, and against the provisions of HMC Act and Building Bylaws 1981, and further direct the Municipal Corporation of Hyderabad to demolish the construction made in the above premises. When the issue was under examination by the government, revision petitioner has filed a writ petition in the Honorable High Court, and the Honorable High Court in the reference cited has directed the government to dispose of the revision petition. In pursuance of the orders passed by the Honorable High Court, notices were issued by reference 6 cited to all the concerned to attend for hearing on 5/5/2005. The counsel for the revision petitioner, the counsel for the respondent number 3, the representative fourth respondent, that is the Nishchit Constructions, and the Chief City Planner, Municipal Corporation have attended the hearing. Heard both the parties and government after careful examination of the matter and the records of Municipal Corporation of Hyderabad relating to permit number 371/4 dated 5/6/1992 observed that in 1991, though the Work Board wrote a letter to Commissioner, Municipal Corporation of Hyderabad, clearly stating that the third respondent, Muniruddin, is an encroacher and land grabber and requested the Commissioner Municipal Corporation of Hyderabad to refuse granting of permission. The plan was approved on the basis of the copies of the judgments in suit, appeal, and the LPA between the third respondent and the district collector, and the judgments filed by third respondent on 13/9/1991. On seeing those judgments, etc., Municipal Corporation of Hyderabad sought for an undertaking from Muniruddin, the third respondent, to the effect that the third respondent and would hand over the land coming under the road widening to the Municipal Corporation of Hyderabad free of cost and without claiming any compensation for the land as a condition precedent for sanctioning building permission. Though no title deeds were submitted as required under Section 429 AA of the HMC Act 1955 and Municipal Corporation Building Bylaws of 1981, Municipal Corporation of Hyderabad has accorded permission when a third respondent agreed to hand over the land coming under road widening. Thus, the permission granted to the third respondent, Mohammad Muniruddin, through the permit number 371/4 dated 5/6/1992 in file number so and so by the Commissioner, Municipal Corporation of Hyderabad, is contrary to Section 429 AA of the HMC Act and the Municipal Corporation Building Bylaws. Hence, the permit number so and so issued by Commissioner is hereby cancelled. 3. Hamiduddin, the third respondent, are at liberty to settle the ownership dispute in appropriate court of law and approach the Commissioner, Municipal Corporation of Hyderabad with the valid title deed for issue of necessary building permission. Commissioner, Municipal Corporation shall consider the building permission after giving due opportunity to both the parties and dispose of the same as per law and as per prevailing rules, so and so and so. Nowhere, my lord, government discussed about what is the locus of this complainant, Hamiduddin, to complain against the building permission which was granted in the year 1992. Nothing has been made out before the government. Government, my lord, receives the complaint of Hamiduddin made in the year 2003, proceeds as if, my lord, he is the rightful owner of the property and he is entitled to complain against the building permission granted to Muniruddin. My lord, my humble submission is government ought to have applied its mind to see whether Hamiduddin has got any valid title or at least prima facie title to question the building permission granted in the year 1992 in favor of Muniruddin. Such an application of mind on the part of the government is totally absent. And my lord, government has mechanically proceeded, my lord, to cancel the building permission, which is not in accordance with law, my lord, illegal on the part of the government. And ultimately, government gives an advice to both the parties. Both of you go before the civil court, get your title declared, and then go before the municipal commissioner for getting the building permission. My lord, without even looking at the prima facie title of the parties, my lord, government takes a decision and then advises the parties to settle their title dispute before the civil court. And the government also records, my lord, that the applicant of the
No,
building.
but how do you meet this finding that you did not submit a document of title along with?
Yes, I submitted before the municipal commissioner, my lord, the judgment in the civil court and also my judgment of this honorable court in first appeal and also LPA. These judgments, my lord, have confirmed that, my lord, Muniruddin has got the title over the property.
Which judgment in?
My lord, the judgments we have filed separately, my lord, your lordship, in the writ appeal, we have filed separate set of documents. In this, my lord, we have filed our title document as well as all the judgments in the.
When have you filed this? Some
my lord,
along with IA or what?
Earlier itself, my lord, not now.
Huh?
Earlier itself, we filed them. Oh, sorry.
That's one.
Iron binding book was filed, my lord.
Not digitized. This not digitized. Digitized. Where is it? When have you filed? How do we get it? We are trying to find out whether that is digitized or not.
No, my lord, I mean,
We don't have the file.
Yes. The earlier occasion when we argued this matter, my lord, this book was found and was referred to by the learned judges also. So I took it for
What is it? Is it like material papers? What?
So starting from sale deed, my lord, first document is sale deed.
No, what is, you have filed it along with a memo? What, how is? Or IA?
Along with an index, we find it, my lord.
Index?
Additional material papers.
Additional material papers. Not opening. Additional, but not there. Huh? Don't have paper. Not there. No, it is not this thing. Not digitized, right? Ah. So record you don't have. It's not there, Mr.
My lord, may I draw your lordship's kind attention to the judgment of learned single judge, para 10 onwards, my lord, there is discussion about these things. Para 10 of the order
Para?
of the order of the learned single judge.
Page.
Para 10, my lord.
Para 10.
Page number 28. It is suffice to say that the third respondent suffered a decree in OS number 510 of 1994. Third respondent, the second dependent in the said suit. The relief sought for the said suit is injunction against third respondent herein and two others, namely Jayalakshmi and Ashok Yadav, restraining them from interfering with the construction work made in premises bearing number so and so, Bashirabad, Hyderabad. The suit ended in a decree. It is also tried to note that the claim made by AP Work Board over the Malgi number so and so situated at Bashirabad came to be rejected by the civil court in OS number 2193 of 1977. The first petitioner is the first dependent in the suit. Three issues to be framed in the said suit, and they are whether the suit property is a work property belonging to plaintiff, whether the plaintiff is entitled to injunction, to what relief. Work board is the plaintiff in that case, madam. A categorical finding came to be recorded in the said suit that the suit Malgi bearing so and so at Bashirabad belongs to first petitioner herein, whether that is the present my client, and this predecessor in interest. There is enough evidence to show that the grandfather of the first petitioner came into possession of the premises bearing so and so, and thereafter he continued to be in possession for over a period more than half a century. A statement of summary of the litigation between the parties is as follows. Then his lordship has given in a tabular form as to how many cases went between the parties.
Who is the appellant? What's the appellant's name? In that para 11 is there?
Yes.
Appellant's name.
Para 11.
No, we just want to know whether appellant was a party to any of the litigation mentioned in para 11.
Many of them. Yes.
What is it?
First one is OS 78 of 66, in which state of AP was the plaintiff and it was dismissed. And second one is Ishwaraya that was dismissed. Subsequently, CCCA allowed subsequently. And your lordship will see item number 7 onwards, this appellant is there, Hamiduddin. Item number 7 onwards. OS 7, Hamiduddin dismissed for default. Then OS 115 of 98, Hamid dismissed or withdrawn. Then OS 16 of 01, that is the against the appellant, dismissed for default. Then Hamiduddin dismissed or not dismissed, he himself. Then OS 99096 dismissed. Then 4504, Hamiduddin disposed of. CC disposed of, WMP pending. A regarding of a reading of the judgments in OS 2193 of 77 and OS 510 of 94 shows that Ishwaraya purchased 741 square yard from the sale deed dated 11/96 from the first petitioner, and sale in favor of Ishwaraya came to be upheld in CCCA number 93 of 1972. Material brought on record also shows that the first petitioner surrendered a portion of premises to the municipality for road widening free of cost. Leftover area of the premises after excluding the extent of land sold to Ishwaraya and measured in road widening would be 614 square yards. While para 6 of the counter affidavit dated 30th/7/2007 of second respondent. It's a matter of record that the corporation refused the permission to the first petitioner on earlier occasions in the years 1970, 71 and 1983. The third respondent, after repeated defeat in the proceedings initiated against the first petitioner, chose to file an application before the first respondent, presumably in the form of revision, as provided in Section 679 of the Municipal Corporation Act. The revision came to be allowed on the ground that the first petitioner has not filed title deed as required under Section 429 AEF Hyderabad Municipal Corporation Act and Municipal Corporation Building Bylaws. The first petitioner has submitted what all documents available with him in order to substantiate his claim over the property. Second respondent corporation, after satisfying itself with regard to the claim of the first petitioner over the property, proceeded to sanction building permission in the year 1992. Well, according permission,
So where is that order granting you building permission?
that was not enclosed in the appeal papers. That was not enclosed in the data field material papers, my lord, by the appellate.
You have a copy.
I don't have a copy, my lord.
Page 105 of additional material papers booklet which was shown to 105.
Yes. My lord, I was reading the order of learned single judge. At para, above para 30.
Yes.
The first petitioner has submitted what all documents available with him in order to substantiate claim over the property. Second respondent corporation, after satisfying itself with regard to claim of the first petitioner over the property, proceeded to sanction building permission in the 1992. While according permission, the municipality has also taken note of the consent of the first petitioner to give portion of the premises for road widening free of cost. The second respondent proceeded to cancel the permission after a lapse of 14 years, that too at the instance of third respondent, who remained unsuccessful in the litigation initiated by him against the first petitioner. This is one side of the coin. The other side of the coin is that the first petitioner filed OS 607 of 94 to declare the notice dated 6/6/94 issued under Section 452 of the HMC Act as illegal. Suit ended in dismissal on 28/9/2000. The inference is that the notice issued under Section 452 of the HMC Act reached a penalty. Within a year thereafter, second petitioner filed OS 601 of 2001 against the municipal corporation seeking injunction not to demolish the constructions. It filed IA number so-and-so and secured an interim injunction. Of course, the third respondent filed IA number 712 seeking his imprisonment as a party dependent. Said petition was allowed, and thereupon the second petitioner hearing carried the matter in CRP number so-and-so, and the same came to be allowed, even at the suit also ended in dismissal. Keeping in view the findings recorded by civil courts, the question for consideration is whether the order passed by first respondent purportedly in excess of power under sections 429 A of the HMC Act and the Municipal Corporation Building Bylaws can be allowed to stand, and the petitioners who constructed the building under the guise of interim orders can be permitted to put to use by themselves or by their parties. The answer to the above referred question in my considered view is that the order passed by first respondent, cancelling the permission at the instance of third respondent, who lost the battle against the petitioners repeatedly, cannot be sustained. And at the same time, the petitioners who completed the construction under the guise of interim orders in a suit filed questioning the notice issued under Section 452 of HMC Act and subsequently withdrawing the same cannot be permitted to occupy the premises till the disposal of application filed by them seeking regularization of the deviations made in the construction of the premises. In view of the above, writ petition disposed of, setting aside the order impugned with this writ petition passed by the first respondent, while maintaining the interim order dated 13/7/2007 passed in WPMP till the disposal of application stated to have been filed by the petitioners under the building perennialization scheme. So, insofar as me is concerned, the learned single judge held that until my regularization application before the municipal corporation is disposed of, I cannot occupy the building and I cannot put it to use. It's so far as they are concerned, their order passed by the government, cancelling the building permission has been set aside by the learned single judge. One submission made by the learned council to lordship is that amendment petition has been filed in the writ appeal at this stage at this belated hour, and seeking amendment of the date from that of 5/5/2005 to that of 3/3/2006.
What is the amendment?
Amendment is, by mistake, in the writ petition prayer, the date of show cause notice issued by the government, my lord, has been mentioned as the impugned proceedings. Instead of the final order, my lord, date of the final order passed by the government. But my lord, entire the body of the writ petition, as well as the counterfeit by the respondent, and also the understanding of the learned single judge, my lord, we are all understood thoroughly. We are questioning the only order of the government dated 3/3/2006. And the relief granted by learned single judge also, my lord, last paragraph.
And what is the date of show cause notice which
Show
has
cause
been?
notice is, my lord, 9/5/2005. 9/5/2005. That was the date mentioned in the prayer in the writ petition. Now we want it to be amended to 3/3/2006 order of the government, date of the order of the government. It's only a typographical error, my lord. I mean that we request the honorable court to kindly, my lord, allow the petition. And so, my lord, your lordship may kindly see, as your lordship, my lord, I am pleased to question whether their title has been declared by any civil court. My lord, so far, I mean, there is no title declaration by any civil court. Whereas my title declaration, my lord, in all the
What is the stage of construction completed?
completed then itself. Completed, my lord, because of the interim order passed the pending writ petition and also the ultimate direction given by learned single judge, we could not occupy it and put it to use until our regularization application is, my lord, disposed by the government. My lord,
When it was completed, construction?
my lord, immediately, my lord, permission was granted in 93. By 94 itself, my lord, construction was completed. Because they were filing my lord, petition before this honorable court seeking demolition of that particular building itself. In 1994, they filed it. That was, my lord, I mean, disposed of, saying that the civil court, civil suits are pending, so this court doesn't want to interfere. So, my lord, building construction was over long back. And after all those things, my lord, entire civil litigation, etc., has been exhausted. My lord, the party landed before the government under Section 79 of the Municipal Corporation Act, saying that, my lord, building permission will be cancelled because I did not produce my title deed. My lord, government also one-sidedly proceeded, my humble submission, did not verify as to date, my lord, the locus to question this particular permission granted in my favor, and also inordinate delay without considering these things as cancelled the building permission. So, my lord, the findings of the learned single judge, my lord, I mean, well considered. I have humble submission, lordship case, my lord, government order is unsustainable. So, the writ petition is, my lord, rightly allowed by learned single judge, and the writ appeal is liable to be dismissed.
Yes, Mr.
My lord, my senior counsel has almost completely covered all the points. I don't like to repeat, my lord. I'll only highlight 2 or 3 points. My lord, I appeal for the developer. The only submission to lordships, the dates of events which are given to lordships, my lord, will reflect, my lord, the intention of the my lord, the writ appellant. You know, if you lordship have the dates, item, my lord, 9 of these dates and events dated 5/6/1992 is the permission. From that date onwards, various proceedings took place between the parties, my lord, including civil suits. And I have given all those dates. After 11 years, when it was unsuccessful, the order, my lord, application was filed in 2003. My lord, after the conclusion of civil proceedings also. My lord, putting the things in perspective, my lord, as far as the municipal permission is concerned, my lord, courts have held that the commissioner does not have the right to consider rival title. Now the writ appellant is none other than a person who's setting up a rival title to the property. My lord, he can't, my lord, question the building permission on the basis of a rival title. Only way he has to go about is to go for a civil court. That is a judgment, my lord, recently our High Court has held, which, my lord, my colleague can pass it on to your lordships, a division bench of Justice M.S. Ramchandra Rao and T. Vinod Kumar, 2021 SCC online TS 1917.
2021 SCC online.
TS Telangana State 1917.
She's good.
This proposition, my lord, that the statutory authority, while considering building permission, would look at a prima facie title, is not finally deciding title of rival claimants. My lord, kindly go to paragraph 28, my lord. Unfortunately, there are no pages in this SEC online. Paragraph 29. page 6, my lord, what you find. Paragraph 28 refers to another judgment, my lord, of Leonard Singlet, which is approved here. My lord, may I read that paragraph 28? My lord? The law, you have got that, Rameshwar versus Commissioner. Paragraph 28, my lord. I'm reading, I'm sorry, my lord, it is paragraph 30. Paragraph 30 at page, internal page 6. My lord.
Yes, yes.
T. Rameshwar as the commissioner, the law as interpreted by this court with the reference to ITMC Act and SHE Act has requires commissioner to consider objections as and when they are raised for granting permission on the ground of title in a pragmatic manner, taking into consideration only prima facie factors. While doing so, the commissioner cannot assume role of an adjudicator or an arbitrator and decide title interacy between the applicant for the building permission and the objector of such building permission. If the applicant is able to show the prima facie such applicant has a right to proceed with the construction, notwithstanding the pendency of any litigation by way of a suit or other proceedings, subject to applicant applying the certain conditions, the commissioner may either grant permission or postpone the grant of permission. This legal position is not disputed by the government pleader. In our opinion, GHMC is not empowered to entertain title dispute and adjudicate the same before disposing of the application for grant of building permission. My lord, pausing here for a minute, the corporation has a power to cancel a building permit under section 450. If lordship can look at page 450, section 450 of the Corporation Act, that is a provision somebody can invoke to, my lord, challenging building permission, but that has a limited scope of, my lord, cancelling it only on the ground of a fraud. If lordship can look at page section 450 of the Act, my lord. (450) is the power of commissioner
Yes.
power of commissioner to cancel permission on the ground of material misrepresentation by the applicant. If at any time after permission to proceed with any building or work has been given, the commissioner is satisfied that such permission was granted in consequence of any material misrepresentation or fraudulent statement contained in the notice given or information furnished under section 428 or 433, or if further information, if any, furnished, he may cancel such permission, and any work done thereunder shall be deemed to have been done without any permission. So this is a provision where a party has a recourse to cancel a permission. My lord, there are several cases, my lord, which includes the judgment I refer to, lordships, that there is a disputed title, people are trying to get a permission and construct. My lord, they are invoking this provision. Sometimes, my lord, commission can entertain this application on they are satisfied there is a fraud played and cancel it. But the writ appellant, instead of invoking this provision, if there is any, my lord, has gone after 11 years to 697. Therefore, I would submit to lordship 697, my lord, is excluded without, my lord, submission that the validity of 697 to take up the matter as a revision. My submission is there is a provision in the statute even for a, my lord, a rival claimant to the extent of building permission been obtained by fraud. That's the only ground on which a permission can be cancelled. Later, if has further, my lord, disputes, only civil court is the resort. That's what the division bench said. And this gentleman has, my lord, gone to the civil court. Well, I have shown your lordships. So the learned judge also extracted 14 proceedings between the parties. 2 proceedings are only relevant, my lord. OS number 510 of 94 is an injunction obtained by the writ petitioner against the writ appellant. There is a permanent injunction referring to the building permission, and, my lord, permanent injunction against the very writ appellant saying that they are restrained from interfering with the construction. That civil decree is passed against him. In spite of that, the government, my lord, is interfering. Then, my lord, the other subject would be the writ petition filed by the writ appellant, my lord, on the same subject matter before this honorable court, which was dismissed, my lord, and that is, my lord, writ petition number, just get lordships. Writ petition number 9096 of 2002. This, my lord, was disposed of by learned single judge, saying that prima facie raised the title. My lord, unfortunately, that is available only in the additional material papers which could not be located. My lord, it is there at page number 108 of that additional material papers, which is there, my lord, with us, but my lord, its physical copy may be available with the court. My lord, we'll see that it is scanned and sent to your lordships, my lord. 108, the writ petition 9096 filed by the writ appellant, in which the writ petitioner is the fourth respondent. The writ petition, my lord, was disposed of saying that, if lordship permit me, my lord, I can just read 2 lines out of that. It is on record. Once the mutation,
order dated.
Order dated. 1 second.
We can get it on the
Yes, my lord.
this order, no, from the
5th December 2003. The date is also very important, my lord. 5th December 2003.
Yes.
And this is, my lord, once the mutation of the name of the fourth respondent, that is the writ petitioner, and permission accorded to him to construct are in subject matter of a suit. The civil court does not intend to examine those very matters in this writ petition. The subsequent extension of the construction permission is another facet of the challenge to the original permission itself. It is not as if with the dismissal of the suit or default, the petitioner is without any remedy. He can initiate proceedings for getting the suit restored or to take such further steps as are open to him in law. Either way, this court does not find any basis or occasion to entertain this writ petition. Writ petition is accordingly disposed of, leaving it open to petitioner to work out his remedy in the pending suit or suit which is said to have been dismissed for default. So, my lord, he files a suit on the very permit, gets it dismissed for default, files a writ petition. The writ petition is also dismissed, my lord, and my lord, the prayer in the writ petition is, my lord, mandamus writ direction, particularly one the nature of mandamus to direct respond number 1 municipal corporation to take action by demolishing the structure being raised by respondent illegally over the premises number so and so in pursuance of the permit dated so and so issued in long back and so and so. So, Lord, this is before the single judge. Single judge said, go to civil court. Your civil suit is dismissed for default. You either go for restoration or not. But leaving all these things, my lord, invokes government, independent of all these 14 matters. My lord, and the government entertains the matter, my lord, after 11 years. Well, my learned friend has cited 2 judgments. My lord, I also filed 2 judgments along with my earlier synopsis filed, my lord, in April 2023. My lord, wherein, my lord, the Supreme Court as well as our High Court have, referring to the suo motu revision powers, said at the late date, even if there is a fraud involved, the revision cannot be entertained because third-party rights ensue. In this case, my lord, 92 permission, construction was completed by 93-94 after a little bit of extension, and my lord, the building could not be occupied because of the orders of these courts. And my lord, interim orders meanwhile. And my lord, the entire building is abandoned because of pendency of this writ appeal. So my lord, he is not getting the fruits. We are only waiting for the regularization. We are penalized by learned single judge. There is no appeal filed. So we will wait for that, my lord, regularization, or it has to demolish to the extent the legal violations are there. That is a recourse to the developer, what he has to do. But as a permit is concerned, my lord, validity is concerned, it can't be challenged after 11 years, my lord, on the ground of one document not filed.
Mr. One query we had, the building permission anywhere, like I hear also it must be valid for a specific time. It cannot be for all times to come.
No, within the time we constructed.
No, no. So what was it valid for 1 year, 2 year, or something, right?
Yes, yes. It was, my lord, in the within the validity period or little later, we have completed
No,
construction.
so we want to know what was the validity period of building permission. 3 years.
Normally, well, I can furnish you lodges, but normally
Validity of
they give my lord 1 year or 2 years. My lord, the time is given.
3 years, he says.
3 years if construction is started within 1 year. Otherwise, it lapses after 1 year.
My lord, I would only submit this, my lord. Even if there are permit violations, that would amount to violation of the permit. My lord, corporation is already given notices of violations. So they're including, my lord, if construction made beyond the permit date. Also, one of the grounds of they have already filed certain recourse to other proceedings have been taken. A suit has been filed.
Mr. Any statutory provision or under bylaws, it is provided that it will be valid for 3 years. There
It will be there in the permit itself, my lord. It will be there in the permit itself. I can file it. My lord, as for the, I only want to make this submission, my lord. We are concerned now with the grant of the permit. My lord, violation of the permit, corporation had liberty to even demolish the entire building if it is a violation of permit. That in fact, single judge also penalized the, my lord, the writ petitioner, saying that you have made some violations. Don't make any get the occupation certificate unless regularization is made or those defects are rectified.
But you have accepted that part of the order, right?
We have accepted. We are not challenged it. So therefore, we will follow. But today, your lordships are, my lord, looking at the grant of a permit. My lord, paragraph 6 of the corporation's counter, they have said that, my lord, they have granted this permission after taking legal opinion about the title.
1 minute, 1 minute.
I'm sorry.
How construction should be raised within 3 months, 3 years. The technique can raised within 1 year or 3 years. Okay, it will be not within the it has to be exercised within reasonable time. I'm not aware. You mentioned about for the year. But in that case, what we have to say in which case we will Yes.
So, my lord, the municipal corporation in the counter have come up and said that paragraph 6, my lord, that they have granted this permission after getting legal opinion about title. So, my lord, they have prima facie gone through according to the rules. Now, my lord, I'll just conclude it on my submission. The learned single judge has gone into details of the litigation. My lord, if it could have been a, my lord, I would say a more based on the statutory violations. It can be well disposed of on 2 points. One, my lord, that the exercise of power by a long delay of revisional power is, my lord, arbitrary. Therefore, it is not valid. That is one ground straight away, my lord, without going to merits of the matter. As in the Supreme Court matter, they said even fraud is alleged, such delay, my lord, will not allow them to interfere in the matter. So that could be the best ground, my lord, on which can be done. Then secondly, my lord, the the entire locus of the petitioner, my lord, the writ appellant, is, my lord, is a rival claimant who had long, my lord, litigation. He suppressed facts with regard before the government with regard to High Court failing to interfere, my lord, refusing to interfere, and civil court suit was filed, dismissed for default. My lord, it may not be reciprocate, but it's binding between the parties. So all these matters, my lord, on the conduct of the party, who has a rival title, question statutory violation, my lord, is also another factor the court should have seen, because it's an equitable jurisdiction. You're also looking at equitable jurisdiction in writ appeal. And my lord, whatever, even if the learned judge has omitted few of the administrative law points, it could be, my lord, corrected by the division bench. My lord, a very interesting judgment I just wanted to cite before lordships with regard to scope of letters patent. My lord, my colleague Kiranmai would pass on that short judgment of Justice Punchi, my lord, reported in 1996 3 SCC page 52. This is a very simple perspective of, my lord, how the writ appeals, rather letters patents, could be disposed of, jurisdictional letters patent. Paragraph 2 of the next page, my lord, page 53. Only one paragraph I'll read. So and so counsel appellant inter alia contended letters patent bench of the High Court could not have upset the findings of recording learned single judge on fresh reconciliation of two documents, arriving at different results of those arrived at the two courts report mentioned. Though the argument sounds attractive, it does not bear scrutiny about the orders of the trial court. The first appeal lays before the High Court both the facts as well as the law. It is internal working of the High Court which splits it into different benches, yet the court remains one. The letters patent appeal as permitted under the letter patent is normally intra-court appeal, where under letters patent bench, sitting as a court of correction, corrects its own orders in exercise of same jurisdiction as was vested in the single bench. Such is not an appeal against an order of subordinate court. In such appellate jurisdiction, High Court exercise the power of a court bearer, so understood the appellate power under letters patent is quite distinct in contrast to what is ordinarily understood as a procedure language. Therefore, my lord, my submission for 2 points. One is, by mistake, show cause notice date is given. My lord, and your lordship, sir, my lord, as a correctional jurisdiction can correct a small error. Secondly, the points the learned judge has not clearly said that it is barred after, my lord, such a delay, but he did say that after an exceptional delay this matter has been filed. But that could be, my lord, at paragraph, my lord, 12 at page 31, internal page 25, the last sentence, the learned judge did say, second respondent proceed to cancel permission after a lapse of 14 years, that too at the instance of third respondent who remained unsuccessful in the litigation initiated by him against first petitioner. This is one side of the coin. Therefore, my conclusion is that the learned judge, in effect, my lord, was right. The reason is given, it could have been a little bit more, my lord, on the delay and other aspects, but it is absolutely, my lord, within the parameters these lordships are held under in the Supreme Court judgments we have cited. Therefore, there is no error with the learned single judge, and it is equitable also. That's all. I'm obliged.
My please. So far as maintainability is concerned, your lordship, the judgment of this honorable court. Judgment. Dealing with the application under 679, this honorable court held that the revisionary power can be exercised at the instance of a aggrieved person. Respondents were directed to pass appropriate orders where when the application was filed, your lordship, before the government, and government was not taking any action against
Which
persons of that. Pardon.
Which paragraph, madam?
From second param. The learned government leader for municipal administration opposed the writ petition and submitted that the action of Commissioner of Corporation in approving the layout would not be amenable to revisional jurisdiction of the government under section 671(1), 679(1). Section 671(9)(1) reads as
Yes, yes,
for our,
yes.
this has become final, Your Lordship. This judgment has been final. No one has questioned this. This is an attained final.
What, you were party to this judgment?
Pardon?
Petitioners were party to this judgment?
No.
That,
Because now they raise that it's
No,
not maintainable.
you can rely on this decision view taken by learned single judge to say that revisional power can be invoked. That is understandable. What is final? They are not parties. Finality, a question of finality arises inter parties. So the appellants are not parties to
I
this.
can only say that power
Their
can
name
be
is not Sabhavat Rukman Nayak, or they are not government of Andhra Pradesh. So there is no question of final.
It can be exercised by the government at the instance of aggrieved party. Because I have as a aggrieved party, Your Lordship, I have filed application under 679, and the government has rightly exercised the revisional jurisdiction and has passed orders on 3/3/2006. That's it. And in this, Your Lordship, now they are harping that it's not maintainable and all. The counter which is filed by the writ petitioner before the government may be looked into, Your Lordship. It's filed along with the synopsis today, Your Lordship, at page 2.
So in the counter, no objection was taken with regard to maintainability.
They have to base their contentions here only on the basis of the counter filed by the writ petitioner before the government. They cannot simply say this is not maintainable and it is filed beyond the limitation time, and as such it is not cannot be entertained. The government ought not to have been entertained. He has given all the judgments clearly stating that his title is declared in that. But all these judgments which he has cited in this counter, on the basis of which the orders were passed on 3/3/2006, are not binding on me, as I am not the party to that proceedings. And here, Lordship, the extracting of the cases filed by the writ petitioners, by the single judge, Lordship may kindly take. There, it's at page 29, internal page 23, Your Lordship. This is judgment of single judge. He has cited some 14 cases claiming that they are binding on me. Here the first case, this is between state of AP and Ishwaraya. That is not, I am not a party to it. Second case, Ishwaraya and government. I am not a party to this. Muniruddin, third, SC. I am not a party. Waqf board against Muniruddin. I am not made a party there. 5, Muniruddin, Nishchin Constructions. That is against me. It is an ex parte decree. This is 607 of 94. This is against municipal corporation, in which he has questioned the notice issued under 452 of the HMC Act as to directing him to show cause as to why the construction which is being taken place illegally should not be demolished. He was directed to stop the construction. This 507 of 95, this is filed by me questioning the very building permission granted, as suit is not maintainable. And that was dismissed for default due to his illness and non-communication of the status by the council. And as such, suit itself is not maintainable. This application was filed under 679 before the government. This was, Your Lordship, copy has been filed. Yesterday, they have given a gist wherein they claim it is an injunction suit. I have filed a copy of the plaint, Your Lordship. It's at page 6. Today I have filed. It's at page 6, Your Lordship. At page 11, prayer is that the mutation and permit number 371/4, dated 6/12/69, he thought that it's 69 because the main application was in 69, obtained by the defendant number 1 in his name for the graveyard property so-and-so, situated at Bashirbagh, Hyderabad, belong to the plaintiff by playing fraud and misrepresentation, be declared as fraudulent, null and void, and cancel and enforceability unlawful. As that was dismissed for default. This application was filed after exhausting his remedies, get himself impleaded in the suits which has been filed by the writ petitioners against the municipality, stop for granting injunctions. This application is filed. As such, they cannot claim that it is filed after 11 years and after keeping quiet. But in fact, I filed an implead petition, which was allowed in their suit, that is 601 of 2001. Your Lordship may kindly see, both the councils have stated the construction has been completed by 94-95. But here, 2006, Your Lordship may kindly see the OS 601 of 2001 is filed against the municipal corporation for grant of permanent injunction. Even by 2001, the construction was not completed.
When it was completed according to you?
It's not even completed till today.
Till today.
Yes. They have stopped it halfway through. It just looks like a booth bangla now.
That's your success, right? That's your success. Oh, lighter when we are saying. Yes, that's it.
And this case, Your Lordship, this as he has filed a case before the Waqf Tribunal, and as this is not a Waqf property, he has rightly withdrawn. That is also mentioned in this. This other suit, Your Lordship, writ petition 9096 of 2012, which my learned brother has mentioned, is filed for not for this purpose, that is filed for mutation of my name. I filed an application for mutation of my name.
What is your locus like? You are the owner.
Yes, Your Lord.
You have purchased the property by sale deed.
I was granted. My father was given a grant. It is a part of a
grant. Any document of grant to your father?
Yes, Your Lord. 1939, firstly itself, it has been granted by Amir Paiga. That's what yesterday I told Your Lordship, that this is a part of Bashirbagh Palace, which belongs to Amir Paiga.
Any document on record?
Documents on record up there, Your Lordship. I have filed as additional material papers also. So grant is there. Moinud Dawla Bahadur's have given the grant, because their private graves are there in that, and for raising a residential complex for myself and to guard the graves, this land is given. That is, they have not disputed, even they have not filed any reply insofar as this is concerned when I filed a vacates petition claiming all this. Now they claim that I have suppressed all the facts about the filing of the suits and everything in the application before the government. But the application is at page 1 to 10 in the additional wetted papers. We have made all mention about all these suits. And this suit, the only suit, this is 501 of 510 of 1994, was decreed ex parte, where an application was filed by me for amendment of my written statement. That was dismissed when I questioned it before this honorable court, meanwhile, when the CRP is being heard, the suit itself was decreed ex parte. And they cannot claim that all these cases have gone against me only when only one suit, that is 510 of 1994, is decreed ex parte against me when the writ petitioner has filed a suit. And your lordship may kindly see the building permission is given in 92. When the application, initial application is 1969, then it is approved in 1992. Now the writ petitioners say that I should not have filed application after 11 years. There is 1969, application is in 1992. After 4 rejections, the only basis on which the building permission was approved is grant and giving an undertaking that he will not claim any compensation for the land coming under road widening. That is not the requirement of building permission. What the government has clearly found after looking into the original documents, that he has not annexed the title deeds, as is essential under section 429 AA and building bylaws, assessed that has rightly set aside the building permission. And this, your lordship, all these illustrations given by this learned single judge with regarding to the suits and everything is between the Waqf board and the writ petitioners. It is clear that it is not a Waqf land. As such, he has rightly withdrawn the suit filed before the Waqf tribunal. And that is also made a mention here saying that I lost everything. When only one case is filed against me for injunction. Why did he file injunction against me? Because I was interfering with his construction, saying that I am the owner. Hence he filed. Now he cannot say that I have not filed any declaratory suit for declaring myself as a owner. When the grant itself is there, he has never questioned, even no reply is filed in the writ petition, saying that I do not have any right over the property. And so far as 679 is concerned, the section itself is very clear, your lordship, at any time. As on the date of filing of the 679 application, occupancy right is not even granted to him, as he has not completed any construction there. So he cannot say that third party's intervention will be given when if it is if their application is entertained after 11.5 years. Even as per the interim directions granted in the writ petition, no electricity connection is given, no water connection is given, and no occupancy right certificate is given. He was restrained from alienating or entering into any other third parties to even agreements to third parties. So he cannot claim now I have to file the application only within reasonable time when no time is prescribed. May I read out 679, your lordship? It clearly says at any time. But they say reasonably, when he has filed injunctions against me and he has injuncted me to not interfere, the only recourse is for me to file a 679. When even the implete petition, he has got it dismissed after by filing a CRP, when that implete petition in his suit is allowed. The only course for me to see that building is not raised and building permission is, because the building permission is granted only on the basis of, it's clear by the counter of the municipal corporation and the government also, that he has not raised construction. May I request your lordship to go to the written statement filed by the GHMC before in 607 of 2001. Additional material papers, your lordship. 114. This is the bundle of page 114. This is filed by the second writ petitioner in 2001. Lordship plot.
What turns upon it, madam? You must first tell us.
Construction is not completed even by that time.
That if
And
you
even
tell us, then we are.
Even with deviations.
Otherwise, we don't get WS in OS. So what is it?
Now they said the construction is completed by 95, 94, 95. That's why this is filed. This is filed by them in total.
No, we have noted down that till today the construction is not complete and it's a haunted house.
This is a
that you told us.
Proof to show that this even the construction is not completed, and with even that construction, which what they have done is with many deviations. And the other judgments, Your Lordship, have cited is with regarding to the constructions made by taking the injunctions, by raising illegal construction, that should not be entertained. That's what. And the other one is BRS scheme was set aside. In that 679 and the other provisions were also noted down by this honorable.
That's it. Right. Arguments heard, reserved for delivery of judgment.
Well, two citations I submitted to Lordship without passing on the copies. May be permitted to circulate to the court officer, my lord.
Yes.
Obliged.
Keep it.
Obliged.
Much obliged.
This all. Madam, one, this, keep it this.
It is. This is a short, brief note or synopsis that is prepared. A brief synopsis that is prepared, if I may be permitted to pass on. The issue order in the application is a 41A notice that is issued under the Stamp Act. First date, that is 33/1999. It is a registered sale deed bearing document number 768 of 1999. Entered into between three parties. One is a vendor, confirming party, and the petitioner. The petitioner was the purchaser of this land.
Not scanned. It has not been scanned. Your case. All right. Yes.
Yes. May I continue, ma'am? Yes. The petitioner here is the purchaser of that land. But the impugned order is in respect of this document, that is document dated 33/1999, document number 768 of 1999. Allegation is of understamping of that instrument. Lordships are aware, the section 3 of the Stamp Act provides for stamping of an instrument, not of a transaction. An instrument is defined under section 2 as any document which records a particular transaction. That is how the definition is. I'll quickly read the section 3 and my lord definition of the instrument. But subject to provisions of this act and exemptions contained in schedule
1 minute. What are you?
Indian Stamp Act.
1 minute. So what have you challenged? Notice issued under
41A
41A.
as being without jurisdiction. Because my lord, what they want to now stamp is goodwill, IPR, which are not mentioned in this document, unrelated to this document, some business sale transaction which has happened outside the state. And my lord, machinery, which my lord, which is again not immovable property, and which is outside my lord, the document that is mentioned. Therefore, my lord, they have no jurisdiction to ask for any.
No, but this pertains to this thing. See, show cause notice you have mentioned.
Yes.
Market difference in market value
Yes,
of the
sir.
land. This thing.
There are 5 things, my lord, that they have mentioned. In my respectful submission, my lord, there would be no jurisdiction in respect of 3, 4, and 5. But once there is no jurisdiction in respect of anything, my lord, that would be an action without jurisdiction. My respectful submission, my lord, that action would have to go completely. And my lord, what is in their jurisdiction, I can explain to them, my lord, if they are only raised in respect of their jurisdictional aspects. My lord, the asking of the amount in respect of valuation of that scheduled property and my lord, square footage are first and 2. My lord, that is a vague notice that is issued to me. On that ground, my lord, that is challenged. But 3, 4, and 5 are completely beyond the jurisdiction, my lord, of the authority is my respectful submission. And that cannot, my lord, from the very inception be even gone. Therefore, my lord, the impugned order is liable to be
But you have
set aside.
not responded to the show cause
But what
notice.
has happened is, my lord, the interim order that was passed that these 4 and 5, no order should be passed in respect of 4 and 5. Other inquiry can go on. So, my lord, after the interim order was passed in this order, this writ petition, I made a detailed reply. After that, my lord, they have taken no action. Writ petition was pending. Then, my lord, the writ petition was dismissed for non-prosecution in 2016 because, my lord, this company was.
So let them decide on this issue 1 to 3.
My lord, 1 and 2 they can decide, my lord. In my respectful submission, 3, 4, and 5.
3 is glass melting furnace.
My lord.
What is this 3?
Yes, my lord. 3 is in respect of, my lord, machinery, glass melting furnace, my lord, we have said that it is embedded in the earth. Therefore, it is part of the sale transaction. The sale deed has schedule 1, 2, 3, 4. Those scheduled properties you can levy the stamp duty. But what is not mentioned in this deed, there cannot be a stamp duty
This
on.
is not subject matter of sale deed.
Not subject. No, plant and machinery is not subject matter of sale deed. Only one glass melting furnace is.
Glass melting furnace is part of sale deed or
That is
not?
sale deed, we have paid the stamp duty. Beyond that, my lord, they want to levy stamp duty on, they claim 75 machineries without mentioning what that machinery is. That, my lord, we are saying it's outside the scope of jurisdiction, contrary to Duncan's.
They have not mentioned that is what the case it is.
1 minute. What is that? This thing you are reading some provision of the stamp
Yes.
act?
Section 3.
41(3) and 41A.
But first I was reading section 3, my lord.
Yes.
Yes, section 3. But subject to the provisions of this act and exemptions contained in the schedule 1, the following instruments shall be chargeable with duty. But what is chargeable with duty is the instrument, but not my general transaction. If I put something on an instrument, that is chargeable with the duty. But instrument is defined under section 214 as instrument includes every document by which any right or liability is or purposed to be created, transferred, limited, extended, extinguished, or recorded. But therefore, this document, which is an instrument which transfers certain scheduled properties, is chargeable to duty. What is chargeable to duty, my lord, is the instrument which transfers these scheduled properties. Outside the schedule, my lord, there is no duty or there is no jurisdiction to charge any duty. Now, your lordships may see what is the schedule in the instrument. The schedule in the instrument starts at page 53. Instrument itself starts at page 15, my lord.
53.
Page 15, the first page of the sale deed starts, that is the instrument. Page 15, and 53 is the schedule. Lordships have 53.
Which page?
53 of the writ petition.
Yes.
Well, schedule 1. Now, this is what is being transferred to me under this instrument. This is land admeasuring 47 acres, 27 buttas. That is schedule 1. Well, stamp duty is paid on this. Issue number 1, my lord, whether stamp duty should be payable as industrial land or aggregated land or as plots. But what they want to say is, we will levy stamp duty as plots. But that, in my respectful submission, I will still answer it, my lord, even if it is remanded. I have in fact explained that industrial land of 47 acres cannot be treated as plots of 200 square feet or 200 square yards, etc. That I'll answer. That comes under issue number 1, my lord, in my note. Then the second one is schedule 2. This is the description of temple land. My seller had constructed a temple that was excluded out of the sale, except my entry. So that is not being sold. There is no dispute with respect to this in the impugned order. Schedule 3. I specifically mention all the buildings. Lordships may see, including restroom, canteens, etc., ST plant, sewage treatment plant, every building that is constructed on the premises, scheduled property, which is embedded there, including sewage treatment plants, etc., are included in the schedule. Stamp duty is paid on this. On this aspect, my lord, they say calculation error is there in terms of square foot, but that is issue number 2, which is only 40 lakh rupees, my lord, the whole value. The duties will be much lesser, but that also I'll explain, my lord, before the authority. That is not an issue. The first issue, second issue, my lord, are all very small amounts. Both I will explain. But then schedule number 4. Specifically mentioned glass melting tank furnace, oil fired in factory building. This is a glass melting tank furnace which is dug up in the earth and it is fixed. So, it is, as per Duncan's judgment, it will be immovable property because this is embedded in earth as a factory. Therefore, I have included in the deed and I have paid stamp duty on this. No dispute on this. Now, what they want to levy stamp duty on, and these are the only 4 schedules on, is what is not sold to me under this deed. That is, what they claim in the notice is some 75 machinery which is outside the scope of the sale. Under this, they do not mention what is that machinery in the sale deed. It is vague. But from the counter affidavit that I see, they say including vehicles. But vehicles are definitely not immovable property. I will show from the counter affidavit that there cannot be a levy of stamp duty firstly on anything that is not mentioned in the instrument, number 1. Number 2, there cannot be any levy of stamp duty in respect of movable property and other machinery which is not mentioned in this deed. So that is therefore, contrary to or in excess of the jurisdiction that is conferred upon them as far as plant and machinery is concerned. That is issue number 3. And I will show from their counter affidavit that they in fact say even vehicles they have included. I'll show that on point number 3. Point number 4 and 5 are in fact even more straightforward. Is point number 4, they say we will levy stamp duty on goodwill that is not mentioned in this document at all and which is executed somewhere outside in my generic the total transaction. But this was a glass factory, one of the glass factories of the companies which has many other businesses outside. But main transaction entered in Bombay, taking over various various factories across the country. This is the only one which is here for which land is taken over. So the goodwill, my lord, which relates to the business is not in this document, and they have no jurisdiction to, my lord, stamp this because it's not part of the instrument at all. The instrument has finished. The last one is, my lord, intellectual property, which is also, my lord, evidently not part of the document. Therefore, it is outside the jurisdiction. 4 and 5. My lord, 4 and 5, in fact, my lord, even the interim order initially that was passed specifically said for 4 and 5, you do not pass any orders on this. My lord, I presume, because it was in 2000, that it was that prima facie case was shown that it is not part of the instrument. You cannot charge some stamp duty to something which is not part of the instrument. But as
So you have already responded to show cause notice, right? We will, in respect of 3, 4 and 5, definitely it needs interference and
yes,
subject to what he says.
yes, only 3, my lord, I
Responded, my lord.
He says the interim order he has filed.
Yes, my lord. In fact, response has been given, my lord, to them post the interim order.
Seeking time, my lord, they have only, they expect.
So let them.
They only sought time.
That is not part of the.
They have not filed the
So
explanation.
they can respond to the notice. You can't recover right without hearing.
They can respond to the notice, my lord. That's what my submission would be.
So this 3, 4 and 5, obviously how can you levy? So what we subject to, if you have to argue anything, please go ahead.
Once it is remanded, my lord, it can be remanded as a whole, my lord.
Why as a whole? So that your officer, you know what, like, we don't want to leave him at the mercy of your officer. And so that he passes an order. You know, Mr. White.
Yes.
Why do you want to, this thing, want us to comment on the functioning of your officers?
Yes.
Why you tell us how it is within jurisdiction, how, why it should be remanded as a whole?
2:30, I'll get in.
2:30, yes. 2:30, Mr.
Should I show that paragraph in the counter, my lord, before?
You can, we will continue.
Yes.
We'll continue.
But Avinash, you have to even answer one question. This agreement, it's like a going concern.
Yes.
This agreement includes as a going concern.
Well,
going concern includes plant and machinery, your assets, whatever is there.
Yes.
So if you have not included that plant and machinery in your agreement of sale, they have to be included for the purpose of duty.
I'll show that. The entire transaction is different. What is this land transaction? I'll answer. I'll answer. Yes. My lord, I was showing those 5 points, my lord, in the note. My lord, in the order in the file itself, that page is at, my lord, page 61. There, my lord, it is subcategorized into 7 points. I'll just go through, my lord, quickly as to which point refers to what. Page 61, my lord, in the impute note. The first one is land value is different, my lord, that I said comes under point number 1. 2 and 3, my lord, comes under point number 2 in my reply. But 4 is a small amount of drawing of water from others. So 1 to 4, my lord, as far as this page is concerned, your lordship may say, my lord, I will go back and explain. But 5, 6 and 7, these are the ones, my lord, where they have no jurisdiction at all. But 5 is value of immovable machinery. They do not mention what is the machinery, my lord, that they are saying is embedded into the earth. Whatever is embedded into the earth in the sale deed in schedule 4, my lord, I have shown it and I have paid the stamp duty. No details mentioned here. My lord, that itself is a ground, my lord, to set aside this order. My lord, 6 and 7 are goodwill and intellectual property. Admittedly, my lord, they say it is goodwill and intellectual property. That is not part of the document. But last thing I wanted to show in the counter affidavit is, when we say there are no details at all, in the counter affidavit, my lord, they mention what they have taken, and it includes vehicles. But that itself shows, my lord, in their understanding what they have taken, machinery could be anything which they have not mentioned to me. And it includes vehicles. That itself shows, my lord, it's out beyond the jurisdiction. Although they cannot explain in a counter affidavit. That is at paragraph 4. It specifically says vehicles and goods.
Para 4 of my counter. Para 4 of my counter, Lord.
No, but tell us, can you like this thing? Demand
1 to 5, Lord, I accept the demand. 6 and 7, Lord, they're not part of the document, Lord. 6 and 7.
No, he said in his synopsis, he has said 3, 4 and 5.
Lord, page 61, Lord.
You don't see, Mr. in your notice, this thing, have you described the, have you given details of immovable properties alleged to be embedded to earth? This, how can, on and this thing, vague allegations you can recover?
No, it's a report based upon a report, my lord. It's a flying squad.
Have you referred to Mr. That's the submission, correct?
It's a flying.
So first, you show us.
They have inspected the property.
No, you have understood what is.
Yes, Lord. It's a notice, Lord.
That is the details of immovable properties in respect of which the deficit stamp duty is sought have not been mentioned. Number 1.
Yes.
Secondly, goodwill and intellectual property rights you cannot.
The notice says that in this regard, it is to state before the registering the document, the so and so has obtained an expert valuation report of the entire land, buildings, and industrial sheds and machinery of the factory.
No, see, Mr. Difference in market value of the land and this RCC, etc. They will file a reply and you decide that.
With regard to the machinery also, Lord, they have only mentioned one machinery, not one machinery, but there are 75 machineries attached to the earth there.
It is not mentioned in your notice.
Report is there, Lord. Report has been referred to. The field inspection report.
Where is the
vigilance?
It is not here. At least I do not know.
Where is the notice?
But notice starts at page 61. But I was sorry. It starts at page 58. And my lord, all other things are mentioned above. My lord, in respect of machinery.
Immovable machinery. What is?
Para 3. Nothing else. Schedule 4 to the document refer to the description of the machinery, but only one glass melting tank furnace oil fired situated at Bankree Building is shown. In this regard, it is to state that before registering the document, Vertotrex Industries Private Limited has obtained an expert valuation report of the entire land, buildings, industrial sheds and machinery of the factory, and the parties have also entered into an agreement dated 4/11/98. This is Thane in Mumbai, Maharashtra. And purchase of the fiberglass reinforcement business of FCB and the Vertotrex Industries Limited, wherein the consideration of the fixed assets consisting of inter alia plant machinery, furniture, fixtures, vehicles, all assets shown in part 1 is shown as total consideration is 32 crores. My lord, this itself says that their furniture, fixtures, vehicles also, my lord, they want to consider for this valuation. It's definitely not embedded. The consideration of land and buildings is listed at so and so. Flying Spot said this. And my expert report is at 20 crores. Next
No, flying
paragraph.
squad, no, that-
I'll read that. Flying squad, after conducting the spot inspection, has prepared the list of machinery embedded and attached to the earth, that is immovable machinery, and arrived the market value of the immovable machinery basing on the expert report, which is the same expert report, 20 crores, which says on the top vehicles and furniture. In the agreement of sale cited above, the consideration of goodwill attached to the fiberglass is 3 crores. Hence, it is treated as conveyance of stamp duty. Further, according to the above said agreement of sale, the confirming parties hold intellectual property rights, trademark, copy of the rights for a consideration of 14 crores. Therefore, this table. So, goodwill and consideration, trademark, they themselves say in some other agreement of sale, which is not in this document at all, it is not leviable to the stamp duty. But in respect of the machinery, also they say vehicles, but they take by some other expert report valuation, which includes furniture, fixtures, and vehicles. And in this notice, they don't mention to me what are those fixed machineries that you are talking about in serial number 5.
Regard to 6 and 7,
Counter itself says machinery.
they are not part of the document. With regard to the 6 and 7, with regard to the goodwill and intellectual property rights, they are not the proper convey, I mean, as per the covenants, they are not included in the instrument. But that thing, I'll not press upon, with regard to the item 1 to 5, with regard to the machinery, the flying squad had specifically found that there are 75 machineries, which has been attached. They can file the reply over there and check them, If there are any objections, they can file the objection, they would consider,
At least you have to give what is immovable problem. Is the C is what? Absolutely nothing.
There is a report attached to this, We'll furnish all the particulars,
That's it.
Yes.
In the
serial number 32. My lord, there the impugned order, my lord, is of 2/3/2016. Another 41A notice issued because, my lord, this writ petition was dismissed for default. Now that this is restored, my lord, that order would
In
have.
view of the order passed, no order is required.
That order would have, impugned order there would have to be set aside in view of.
In view of the order passed in.
Deeply obliged.
Hmm? 30. And this, keep it there in that. 33 to, where is the list, Manu? Here. 30.
Second, September 2000. Back is to appear. After in speech of some suddenly I will have lots of.
What?
Then back. Lord's order come back.
My lord's order is there.
Oh.
Suddenly we get it. However much the pressure for us appear.
No, because instructions have been issued to list the cases in chronological sequence. That's why it has come up. 2005 matter, Mr. 18 years.
Suddenly, because we could get rid today, because even synopsis we do not.
So let it be this thing in the list. We will take it up tomorrow also.
Since as per your lordship order, pleasure, you know, this is come up with the trustee. We have not had it very because it's a big batch. If your lordship give me at least a week's time, next Wednesday we get it. Beyond that, no, it's not possible for us to prepare the case and satisfy your
Hey, what is the issue involved, Mr. Prasad? Not out of something world, right? What is it? Has to be a case. What is it? Please tell us. 1 minute, 1 minute. We'll find out. You are finding it so difficult to prepare. So we are curious to know what is it that a senior counsel like you is finding it so difficult to prepare, that not ready and this thing. What is it, Mr.?
The acquisition of land for IT purpose, for IT park,
Ah.
extent of 400 odd acres.
How many acres?
400 odd acres
Ah.
sought to be acquired. Not? Policy as such has been challenged in the writ petition by one of the petitioners. Other petitioners are.
What on the ground? Violative of Article 14, arbitrary. What else? Right?
And the
Policy of acquisition.
It's not answered by the Honorable Supreme Court.
notification.
Are you looking that the issue has been answered by the Honorable
Notification is also challenged
Notification.
because they have not followed the procedure.
All right. So what is it? Like 2 points, right? So policy of acquisition is arbitrary, violative of Article 14, discriminatory, whatever. And second point is that the procedure prescribed under the Act has not been followed. So what is so difficult that you can't get ready?
Larger questions are all.
No, we will grant adjournment, Mr. But this is, we urge senior counsels to cooperate, Mr. This thing is the only one thing, Mr. Please, we have absolutely no problem in adjourning all the cases, right? As if it appears that we are the landholders, we want to quash the proceeding, or we are state government. It's like this. We have absolutely no problem in adjournment. But see, we are taking it under a drive to decide old cases. If it is agreed. I mean, I did not note this thing that this order could be made a ground to seek an adjournment. So,
Next week, not only 1 week, next Wednesday, get ready and
please argue. Next date, please don't seek an adjournment and embarrass us. We will have to say no. Respecting your this thing, we are adjourning, but please do argue. We will not adjourn. No, even if you don't commit, you have to do it. Eventually, it's if you don't commit also, then you have to do it. We are telling you. This is only subject to 136. You can challenge this order, refusing to grant adjournment. Yes.
One more aspect, which in the item
it's being adjourned, Mr.
34. No, I filed 2 IA interim applications are there that may be ordered so that I will be ready.
What?
One is the amendment of the clause title. My name is not properly.
Which?
Item 34, IA number 1 of 2023 and IA 2 of 2023.
1 of 23 amendment, yes.
2 of 2023.
There are 2 applications for amendment, right?
One is for the amendment of the
Prasad.
clause title.
Applications come back. I looked into the application and come back. I'm sorry, I've not looked into it. No, one application.
But reason is, the second 1 minute. Let me mind. Wait. In the second
you say, please, Mr. Let him say. No, you said something, no? Oh, yes. What? Let him complete.
In the second minute, I have detailed the events which happened subsequent to the filings. They issued the notifications, notice under 4.1.
That is the amendment this thing you are seeking.
Bringing IA 2 of 2020. Because that events would also have a bearing in the adjudication.
Same time, Wednesday, or can consider.
Yes.
Because if they are allowed, I am ready to proceed.
No. He says he has not seen it. On that day, we will allow and proceed, right? Nothing.
Amendment petitions are there, because Supreme Court, Honorable Supreme Court, while remanding, submitted the
amendments and
by 2 orders separate.
We are not saying that we are rejecting it. Only we are. Your friend is. He says that.
Say something on
It's there.
We'll consider it on the next date when we finally decide. So tell us the date of your choice, Mr. What's your name? Right? Learned senior. Learned senior counsel for the app. Yes. Take it, madam. So, Mr. This is new this thing, right? You should also be ready with such order sheets and seek adjournment. It can't be. We are not ready. Huh?
With your kind permission,
Yes.
item number 53, I appear for the appellant, my lords. I filed IA 1 of 2023.
Huh.
Through the GPA, the appellant allowed a vote on record, your lords. The same is allowed. The parties are also thinking
What
on
is
terms of compromise.
50? No. What happened to 53 up to 53 adjourned, right? Hmm. 54. So, who has died, madam?
Appellant number 1 is dead, your lords. I filed.
So please go ahead. The application is allowed.
Very well, your lords. The parties are thinking on terms of compromise. My lords may see a short date.
No. Nothing.
The parties are thinking on the terms of compromise, your lords.
15 years, madam.
Once the parties come together on the terms of compromise, I'll be able to present to this court.
Supposing if they don't this thing settle the matter for another 6 years, do you expect this court to this thing grant adjournment?
My lords may strictly say 1 week, your lords. I'll close the writ appeal itself.
This is what happens when we grant adjournment. This is what happens, Mr. Counsel. See, no. This you see what this is our predicament. One case you sought an adjournment. She is feel inspired and seeking adjournment. Just now we have adjourned one case. How can we say no? All they seek inspiration from you. They feel inspired that senior counsels are seeking adjournment in old cases. Court is granting, and we don't have any moral right to refuse adjournment. All right, madam.
1 week. 1 week.
No. Why 1 week, madam? 1 year. 1 year.
My lords,
Why 1 week?
come back with the compromise terms.
After 1 year, no hurry. Why? Why this court should hurry, right? You have a right to seek adjournment, and that is appears to us you are treating it to be a fundamental right. What can be done? Thank you. Yes. 55, 54. Third on IA number 1 of it.
Can I file the synopsis?
Which case?
The matter
It is
for
being
lordships are adjourned.
adjourning. She is praying for adjournment.
I am opposing, my lord. I filed
Madam. So now there is no you are tell me as if it's not our case, right? Please you make submissions so that she can hear. She is saying in your presence that it is being like this thing matter is being compromised and she should be granted time to report settlement. This is the submission.
I have no instructions so far as compromise is concerned. I have no information.
There is also a connected contempt to this writ appeal, your lords.
But the counsel says that he has no instructions for compromise. On what basis you are making this statement?
My lords, my client has come with the terms of compromise as first terms. Once they finalize the terms, I'd be able to present the same.
Sir.
But so far as my client, my instructions are
Speak into the mic so that she can hear.
I have no instructions, my lord. I have no information that any compromise is taking place.
So, madam, what should we do then?
May I suggest?
Now you tell us.
May I suggest only Friday's time, your lords? I will close the writ appeal itself if there is no compromise. They only wanted the terms to be recorded in the court, so I'm seeking an adjournment.
Monday, Tuesday, whatever.
You may say finally. Because she says there is a compromise, whether there is a compromise or not, at least let her report on that day.
Yes.
I agree to that, your lords.
Third on IA number
You for me. Counsel for the petitioner. I am representing B alpha of the Mr. Venkata Prasad. I am representing B alpha of the Mr. Venkata Prasad. So we need a small adjournment, sir.
No, no adjournment. You tell us what is the matter about. Yes.
We need a small adjournment.
No, not even small or large. Nothing, no adjournment.
Actually, my senior is suffering from such a health issue. So that reason he not able to attend the court.
Huh? You are able to attend the court, right?
I'm
You are able to attend the court, correct?
I'm able to attend, but sir, actually I don't have any instruction.
Then we will dismiss it. That if you don't have any instructions, we will say so.
No, sir, small.
We will record your submission. No, no small. Nothing.
Next day,
No, there's no question of small, right? We will decide the case today itself. So the question of small or large does not arise.
Only one adjournment, sir.
Huh?
Appearing for the respondent of the court.
What is it?
It is covered by the judgment of this honorable court. In respect of the very same part.
He has challenged this thing construction which has been raised by.
In respect of the plot number 723 and 724. No? That is a part of the.
Yeah. What ground he is challenging? You give him also order.
Yes.
This is public interest. Oh. Forget about it. This is public interest, mister.
In respect of very
you have lost locus now. Once PIL is filed, you have lost locus.
Single adjournment.
This is a public interest litigation, correct?
Yes.
Then you have lost locus to seek adjournment.
The first paragraph itself, plot.
You read, mister. Read the judgment of Supreme Court, right? Sheila Barse. What does Supreme Court say? Now it's our case. We will deal with it. Don't worry.
The judgment of the first paragraph in respect of the plot number.
Different plot number.
Yes. In this plot numbers are 723 and 724. That is covered in the judgment. Respect of construction made in this law.
Yes. This petition which has been. It was so simple, right?
For the petitioner, that's the petition is filed challenging the impugned orders, my lords, passed by respondent and a demand notice.
The question of law, my lords, is whether the property tax can be levied on the educational institutions and charitable institutions, my lords. Well, the earlier occasion, lordships have directed us to verify whether the cost survives in this matter, my lords, because subsequent to the GO, my lords, GO number 468, there was amendment to the Act, my lords, that superseded this particular GO, my lords. So, lordship may kindly accommodate in one date, my lords. I'll argue the matter, my lords. I'll verify and argue the matter, my lords.
Nothing, don't verify. We will decide it today. Nothing to verify.
Tomorrow, if your lordship may accommodate tomorrow, I'll verify. And
why? See, when were you granted to verify time? When were you granted time? See, 1910 also this matter had come. You did not appear, we adjourned it.
The case of the petitioner, my lords, petitioner is a registered society, my lords. Under the Societies Registration Act. The purpose of the petitioner, my lords, is to impart education, my lords, to the students in the locality.
No, what have you challenged in this petition?
The impugned order, my lords. Page number 11, 12.
Difficult.
In the earlier round of litigation, my lords, when
there was impugned order dated 4/12. Under which provision this has been issued? 4/12/2007.
I'm sorry, my lords, I'm unable to get.
Under which provision of law the impugned order has been issued?
My lords. Section 88, my lords, of AP Municipalities Act.
AP?
Municipalities Act.
So this is, you own a property within the municipal limits, right?
Yes, my lords. Yes, my lords.
So therefore the amount has been demanded from you. So where is this thing?
For a moment, my lords, your lordship may see, my lords, in the affidavit, my lords, lordship may see para 4, my lords. We have referred. GOMS number 468, dated 31/7/1993. My lords, says, my lords, all the educational and charitable institutions are exempted from paying the property tax, my lords. Under this exemption, my lords, we have given a representation that was not considered. Without even going into the representation, my lords, they have passed the impugned order, my lords. In the earlier round of litigation, my lords, this honorable court has passed, my lords, not only in our case, my lords, in a batch of writ petitions.
Order dated 4/12/2007.
Yes.
Is under challenge.
Municipal corporation, Lord. Earlier, no. Yes. Subsequently, in pursuance of consideration of the representation, this impugned order was passed and property tax was assessed. In fact, they are paid earlier also. Now, the exemption was granted only to such of those institutions which were not running charitable institutions.
1 minute.
Yes.
We just asked you what is the impugned order. You are telling I am appearing for municipality. This is not the answer, right? We asked what is the impugned order.
Impugned order is at page number 13. 11.
So is it not a recognized educational institution?
Pardon?
Is it not a recognized
It's a
education?
recognized institution, but it should also be milord, a charitable purpose. Milord, they should not collect any fees.
Where is that?
Milord, your lordship may kindly see, milord, we have filed counter also. That is exacted in the
No, not counter, provision.
provision. Yes. 88 milord once.
Which act?
88. Milord,
Which act?
AP Municipalities Act, milord, 1965, milord, earlier, milord, it was. Now it is milord, Telangana Municipalities Act, 2008. Section.
This is all based on this interpretation.
Section 88.
Recognized educational institution including hostels, public buildings. And places used for charity. And is disjunctive, mister. Your officer is reading the definition incorrectly because he doesn't have a legally trained mind. Same thing. This use recognized educational institution including hostels, public buildings and is disjunctive and places used for charitable purposes. That does not mean that educational institution, whatever place is used for charitable purpose of sheltering destitutes or animals, and libraries and playgrounds which are open to public are exempted from property tax. This is the purpose. We have understood your argument that it is not used for charitable purpose and they are charging fee from students.
Yes.
Act. Can you give us the act?
Yes.
This not this thing. Correct. Building one draw. All right. Anything else?
That's liable to pay, milord. In fact, milord, without any milord objection, earlier also they have paid. I extracted in my counter also, but I filed counter.
No, if they are ready to pay, we don't have any objection. But we will decide if you are asking us to whether they are liable to pay. If he wants to pay, he can.
No, Milord,
We are not prevent him. You want to pay?
No, Milord, as of now, we don't have any instructions as such. That is the reason why we are before your lordship.
So you are seeking an adjournment, and all of a sudden you have got instructions that I will not pay.
No,
why?
That's to Milord.
And so you argue your case, mister. It's not that burden is not on the court to find out. Why this, it should be quashed?
Milord, as per the GOMS 468, Milord, all the educational and charitable institutions have been exempted, Milord. Even in the earlier round of litigation, this honorable court, Milord, has passed the detailed judgment, Milord. So lordship may see page 18, Milord. Division bench of this honorable court, Milord, has passed. I'll read out the extract, Milord, page 18, Milord. Mr. C. Kodandram Learned Counsel appearing for the petitioner submits that subsection can be interpreted to mean that all the recognized educational institutions are exempted from tax under section 85 of that. He places emphasis on the word and before, places and after buildings to give such an interpretation. But in our view, the most important word in the whole subsection is including, before hostels and after institutions. The word including is read along with the word and, which is found in between the places and buildings. It becomes crystal clear that the recognized educational institutions shall be exempted from the tax, where the educational institutions which included hostels, public buildings and places used for the charitable purpose or for the purpose of sheltering destitutes or animals or libraries and playgrounds which are open to the public. There was no need for the legislature to use word including. The intention of legislature was to exempt all the education. Therefore, in our view, all the recognized educational institutions, including hostels, public buildings, and places used for the charitable purposes, are exempted under Section 85 of the Act, provided those institutions include hostels, public buildings, and places are used for charitable purposes. That the charitable purpose is necessary only for the places other than recognized institutions, as suggested by Mr. C. Kodan Ram, the Council, is also accorded to us. Is not correct. However, it will always be a question of fact whether a particular institution is a charitable institution or educational institution. Therefore, while answering the reference in the term, as mentioned here in above, we make it clear that we have not gone into the question as to whether the petitioner institution are charitable institutions or not. My lords, without following this judgment, my lords, the impugned order was passed. Well, Lordship may see the impugned order, my lords, page 11. They've just blatantly said, my lords, that the petitioner institution is not a charitable institution.
Oh, no, council, on what basis you are saying that it's a recognized institution? Are there any proceedings to that effect?
Yes, my lords.
You have simply stated that you have been recognized by the government. Is there any proceedings?
Any proceedings?
What is the procedure in recognizing institution?
Recognition is not accorded by the concerned universities. So far, this institution is concerned, it is recognized. But the thing is, it's not running for the purpose of charitable purposes. You have stated so in the counter also, they are collecting AV fees. Last my kindly page 3 of my counter. It is not that we are not considered. Page 3 of my counter.
Recognized by the government of Andhra Pradesh. Okay, they don't know anything.
That's two aspects, my lords, that I need to clarify, lordships. One is, my lords, as my learned senior said, whether the petitioner institution is ready to pay the tax or not. Other, my lords, whether the subsequent amendment to the act has superseded the GO. That I need to clarify, my lords. Lordship may have.
No need to clarification, Mr. Even if it is superseded or it has been amended subsequently, that does not obliterate your liability to pay the tax for the period in question. Not like all the time seeking adjournment, right? What is this? You come here to seek adjournment or argue cases?
Argue.
Then please argue. We are giving you an opportunity. The focus is on seeking adjournment. That's the problem. Supposing if it has been amended, if the provision has been amended, will it obliterate your liability to pay the property tax? Obviously not. The liability will remain, no? That we have understood.
The counter we have stated earlier also they paid the tax. Now, you lost my kindly, Miller.
They may have paid the tax. You should be happy with this.
No.
Now they don't want to pay the tax. What can we do? So we cannot say that earlier you had paid tax, pay also, now also. Can it be a judgment like this?
Yes.
Earlier, you can't say. That's all. Anything else?
Nothing.
Nothing. Oh,
No.
We are happy.
By
You are saying nothing.
It's not a charitable institution.
That is not the requirement of law. It is. You can succeed only if you are able to show that it is not a recognized educational institution. That's all. It's this thing. Fine. In this
May it please the Lordship. May it please the Lordship. The petitioner was appointed as stenographer, now called as PA, in Kayamala district on 9/10/92. While he was working so, in 2005, some anonymous petitions were sent to the High Court against him. He was forwarded to the district judge.
My lords, may I give the synopsis, my lord? I have prepared detailed synopsis.
I submit the facts. The petitioner was appointed as stenographer by the district judge Karimnagar on 9/10/92. Now he is called PA to the judge. Some anonymous petitions were sent against him to the High Court.
No.
Some anonymous petitions were sent to the High Court in 2005. The Honorable High Court sent them to the district judge for inquiry. The district judge might have made some preliminary inquiry and he suspended the petitioner and ordered for an inquiry. The inquiry of the allegation against him, is that he is collecting money from the accused at the time of typing.
Collecting money from
the accused.
Accused.
At the time of typing the TSHC examination and also at the time of judgment. That is the only charge against him.
Only?
That's the only charge against him.
Not sufficient, right? Only charge. No. Yes. A departmental inquiry has been held. He has been found guilty, right? Departmental inquiry has been held against him, right?
He was suspended the decision and ordered for an inquiry. He was suspended by the decision and ordered for an inquiry.
That's what we are saying, that in an inquiry, the charges leveled against him have been found to be proved, right?
But the decision imposed the punishment of the postment of 3 increments with cumulative effect. But the Honorable High Court, when he preferred appeal,
enhanced to dismissal.
No. When he preferred appeal to High Court, he relied upon judgment of his division bench of the High Court that I'm sorry. He has withdrawn the appeal. The High Court gave a notice why he should not be enhanced. Then he has withdrawn the appeal. The division bench of the High Court held, and once he withdraws the appeal, the High Court has no power to impose punishment. That's the judgment of division bench.
No, but this notice.
Notice is given as session.
Notice given was before dismissal of your appeal.
Before this
as withdrawn. During the pendency of the appeal.
When I filed the appeal, the Honorable High Court gave notice under Rule 37. Why should I be unanswered? Then I withdrew the appeal. Then the High Court gave notice. There was a decision of the division bench that when once he withdraws the appeal, the High Court has no power to impose any sentence.
Before withdrawal of the appeal, the notice was issued. No, but this during pendency of the appeal, it could have been notice could have been issued. Yes. What does this judgment say? Which paragraph? What?
Had not had not extra substance.
What had not, Mr.
Now I will feel body and.
Huh?
Supreme Court judgment.
Yeah, this is a charge relating to integrity of an employee, right? Dishonesty, demanding bribe from the litigants, accepting bribe. It's a serious charge.
But
This thing, what?
High Court found it cannot pass any order under Rule 37. Then it gave notice under Rule 40.
Which paragraph, Mr. You are relying upon? What? You say that after, tell him after dismissal of the appeal, but during pendency it can be withdrawn. Notice can be issued on enhancement.
Another judge is extracted the Supreme Court judgment.
No, what is wrong with the notice? During the pendency of the appeal, notice was subsequent was issued. How you are finding fault with that?
No, then once I withdrew the appeal, the Justice Redraw's bench said the High Court has no power to impose the punishment. I will read out the judgment of Supreme Court.
If the appeal is withdrawn, then the punishment would have to be implemented. If you're on your own accord, if you're withdrawing your appeal, what further lies?
Then it will go back to the punishment given by the district judge. The district judge we should avoid punishment of the
My lords, may I clarify, my lords?
Don't go anxiety.
What had happened in this case?
No, you must be complete what is your anxiety.
Yes, sir, please.
I'll read out the judgment.
No, you were just giving some clarification on factual aspect, not arguing. Huh?
Sorry, I'm sorry. You don't do me very well.
Yeah. So once you are saying that once appeal has been withdrawn, the court has no power to impose punishment, right?
That's what Supreme Court said, and what is division?
Where it is said, you are not reading that.
Para 7 onwards.
Huh?
Para 7 onwards.
Which is this division bench judgment? Which judgment? Division bench?
Division bench judgment.
Para 7.
Supreme Court judgment in extenso. Para 7 on the other hand. On the other hand, the Renal Council for the petitioner permits that once an appeal filed by the punishment is withdrawn by her, the appeal authority has no option but to dismiss the appeal as withdrawn, and in fact, if such application is made, the appeal authority cannot exercise power by modifying or enhancing the punishment. In this connection, the Renal Council, upon judgment of Supreme Court reported in MD Maharashtra Cotton Coed Market Selection Limited, Saugure, Perra, Purpose Law, Anna Sahib, and others. The facts of the case of the Supreme Court are identical to the present case, and the judgment of the Supreme Court is very short. Will reproduce it in full. Leave granted. Had counsel for the parties. Respondent number 1 here. Eligible for complaint such as respondent. Is the result that the department inquiry will inspect the against him. Inquiry of only value to against the respondent. However, the Supreme Authority imposes a minor punishment. The inquiry officer from the director for recovery of sum of 9,000 from the respondent and stoppage of his promotion for a period of 3 years. Accused the respondent filed an appeal against RP imposing minor punishment. They revealed that the respondent gave an application for withdrawal of the appeal. However, the appeal authority continued the appeal and enhanced the punishment by passing an order of removal of against the respondent. The respondent thereafter prepared a petition to the High Court, challenging the order of the appeal authority. This petition was allowed in part. It is against the judgment the appearance is in appeal before us. After having held learned counsel to artists and paid record, we have used that once the delinquent officer has withdrawn the appeal, there is no valid reason for the appeal authority to have proceeded the appeal. Besides, there was no suo motu or any other power under Rule 53 of the Discipline Appeal Rule to the appeal authority to enhance the punishment. We are therefore in agreement with the views taken by the High Court. So next submitted by Alan Rao, learned senior counsel that in any of the matter, the High Court fell in error in directing the appellant to pay the entire years of salary to respondent. We find merit in this argument. The respondent was partially guilty of charge, and as much he took regular employment after he was removed from service, in the facts and circumstances, we modify the order directing for payment of entire years of salary, instead direct that the respondent given half of the back salary. With this modification, with this modification, the appeal can dispose of. Then our High Court, coming to second contention, we have seen that not only the report of the inquiry but material record certain error, experience matter was also taken into consideration. This fact is also important, sir. The inquiry also recorded evidence of two witnesses, for which there is no charge, and it was relied upon by the decision and the High Court also. I will read out that portion also in the order of the Honorable High Court. Coming to the first response, appeal authority was framing the opinion of dismissing the petitioner from service in the order passed to the relevant judges and administrative side before issuing the show cause notice for enhancement of punishment. The relevant judges had noted that the punishment of removal from service if ordered would be proportional to the gravity of the charge pool. It will be mentioned there that the appellant is only a temporary employee in the unit of decision Vespucci at Ero, having been selected and appointed the decision himself, without his name being forwarded by the Service Commission with Execution C. She has not been regulated by the Service Commission, and obvious of the fact that other service has not been regulated, the appellant has exhibited a conduct which is unbecoming of an employee, showing utter disregard to the officer under whom she is working by going away with files and threatening the report registry. By deciding the appeal, the appeal authority perhaps thought it necessary to remove the prisoner from service as she has not been appointed regularly and her name has not been rewarded with Service Commission. This was not a matter which has to be taken into consideration by deciding the appeal of the prisoner against the punishment which has been given to her by her misconduct. For reasons we allow the decision, set aside the order, however, she dated 4th October, passed to the first respondent. However, the order dated 6/2000, passed by second respondent stage, imposing punishment of withholding incremental, unincremental prisoner is upheld. The prisoner shall be taken back in service immediately and she shall be entitled to all the attendant benefits from the date she was dismissed from service. Then realizing that the High Court has an appeal authority under Rule 37 has no power to do it, the High Court did much worse thing. It gave notice under Rule 40, which is to be done by exercising revisional powers. The High Court cannot be
What are you referring?
parties of CCI rules.
Dismissal.
The High Court took up the powers under Rule 40.
Retired long back. Question of restatement. Back regularly.
Rule 40, the revisional powers.
Rule
40.
Yes.
The High Court cannot have both the powers, appeal authority and revisional powers also. How can the High Court have? There must be some other authority Over and above the author, that is the contemplate rule 34(1), kindly see, sir. Kindly see rule 34(1). Governor is appearance authority. Governor is appearance authority of the High Court. Rule 34. Rule 34. The High Court cannot be appearance authority as well as revision authority. The revision authority should be superior to the appearance authority. Rule 34 kindly see, sir. A government servant, including a person who has ceased to be in government service, may prefer an appeal against the editor. Any of the orders expressed to the authority as follows. An appeal from an order by the High Court shall write to the governor. Even if the hardship was that the High Court has got trivial powers. As the head of the department.
There is no question of appeal here. You had filed an appeal, you had withdrawn it. So what will lie to governor?
No. They dismissed the exercising the regional powers, not appeal powers. Regional powers.
So what is first submission is that this once the appeal has been withdrawn, the punishment cannot be enhanced. That is one argument we have understood. What is the next?
That is accepted by the High Court. No, it gave notice on the rule party as regional powers. That is accepted by the High Court. It initially gave notice under Rule 37, Appeals Authority. Under Rule 37, Appeals Authority gave.
So High Court is appellate authority, therefore under Rule 40 cannot issue notice as revisional authority.
High Court cannot be appellate authority as well as revisional authority.
Yes.
And kindly see, it is stated the revision cannot be entertained provided no power of revision shall be exercised by the head of the department. High Court is the head of the department. Rule party proviso says, provided further that no power of revision shall be exercised by the head of the department unless the authority which made the order in appeal or the authority which appeal shall lie, where no appeal is preferred is subordinate to him. When no appeal is preferred. In my book it is on page 126. Same now?
We have?
No, the High Court as head of the department cannot exercise the revisional powers. That is the rule says, statutory rule. So the third power is to section 40. Kindly see, sir. The no power of revision shall be exercised by the head of the department. So the High Court exercising both the appellate authority as well as revisional authority, it cannot be so. The revisional authority should be governed by the appellate authority.
You are repeating it. The third time you are telling us. High Court cannot be appellate as well as revisional.
Yes,
so go ahead, then what else? So then.
No. The governor. Governor, under Rule 34 has said.
Governor should have given you notice for enhancement of penalty.
Yes, sir.
Yes, understood. What else?
No power. So I submit that.
Therefore, he should be reinstated with all back wages.
Back wages
Yes.
and some benefits.
All benefits, yes.
If was to us, the punishment imposed by the district can be retained. The punishment of the postponement of free increment by the district judge, that may be retained. Was to us, not deserving everything and leaving him the road. He's a man. He's unable to educate his children. He's unable to get married. The 40 years old children are there. 30 years old children. And he cannot be made to roam in the road for a small allegation.
Small allegation? I am told by brother that you have been a district judge. At least you cannot say a small allegation. It's a matter pertaining to integrity, Mr.
Anyway.
Accepting bribe from litigants, you are saying a small issue.
There is no
You have not challenged. You have not challenged the findings of the inquiry officer on merits. It's not the allegation against him of accepting the bribe is proved. The only on technicalities you are arguing.
Kindly see, the Honorable High Court, the High Court relied upon hearsay evidence and they rejected the direct evidence. And kindly give me 5 minutes time.
Huh? Why not?
The High Court
Argue, please.
relied upon hearsay evidence. Take evidence secondary. Evidence. Kindly see, sir, page 132, sir. Page 132, sir. The High Court relied upon hearsay evidence and extraneous matter. It is not subject matter. Page 132 onwards, the evidence is there, sir. The lowest portion of 132.
See, also obtained 5,000 rupees for order in non-payable. Just we are reading this, some of the allegations against.
There is no charge for it.
500 for attestation of affidavits, collecting amounts for getting jobs to unemployed persons in Karimnagar district.
No. Your Lordship may kindly see, there is no charge for it. It is extraneous consideration, taken into consideration by the inquiry officer, district judge and High Court also. That paragraph 14 and 15, there is no charge at all.
No charge? Then how have you been punished?
Punished because of this hearsay evidence.
There is no charge against you, so therefore departmental inquiry could not have been held. No punishment could have been imposed. Correct?
There is a charge with regard to the corruption of the amounts of the accused. All the witnesses say, for education, Vakil's clerk say, all the advocates and examined, and the advocates clerk say, we have heard. Paragraph 136, page 136. Page 136, sir. TW4, the General Secretary of the Bar Association met Parley. He stated the Bar Association passed a resolution with secretary advocates. The evidence could show that when the apparent approached them and expressed the difficulties and problems, they passed the resolution did not support the specific instance of the apparent collecting money from the accused at the time of the examination, at the time of acquittal of the agreement. There is a direct evidence of the Secretary of Bar Association that he is an honest man.
See,
the four advocates and Vakils.
This thing, 2 advocates and this thing, President, Secretary, everybody is deposed to 4 witnesses.
The four advocates and Vakils clause, they have stated, we have heard that he collected money. The High Court powerfully taken into consideration that hearsay evidence and rejected the direct evidence. Paragraph 136 of page 22, sir.
Inquiry report. I'm looking at the record. Yes, yes, go ahead.
Page number 26, the charge is there. Lordship is referring to collecting $5,000 and that is bad. But the charge is not covered by charge. Page 26, pen 6, page 26. Sir, I am the personal state port of Union Anthony. Like personal state is port of Union. I demand a capital amount for discharging of field duty. In typing examination equivalent to HIGHCOURT and TSHC and the time of announcement of judgment, make false promises, misrepresent the fact in the name of the head officer, defying the name of the officer, and thus is liable to get of their misconduct. They had charge about collecting 5,000 hardship is referring to. There is no charge at all. Apart from that, the officer under whom is appointed, working as a client, he is not appointed, he is not examined. The officer under whom he is working is not examined by the inquiry officer. He examines extraneous witnesses.
PW5. Page 49, PW5. Yes.
Sir, I submit once again, the Lordship was not including to. The Lordship is not inclined to extract him in full.
Huh?
If your Lordship is not inclined to examine him in full, the punishment given by the district judge may be maintained and he may be reinstated into service.
Okay.
With some benefits. Right? That's all.
That's it.
Right.
We'll hear you tomorrow. Yes. Right, Mr. So and so, learned counsel.